be back shortly. Mr. Edwards, is there anything that you would like to discuss before we bring the jurors in that's not on the record? I don't mean it because that makes it unofficial, but it's things we can talk about. You don't care that they're not taken down.
No, sir, we're good.
Okay, glad to hear you're good. Ms. Medwick, anything?
No, Your Honor.
Ms. Sturm, and good afternoon to everyone. I should have started with that. I just putting out a fire in another situation. Anything on behalf of the Davids before we're on the record and we're bringing the jury in?
Let me just check, make sure that I'm not reverberating.
I was the issue. I hadn't muted me, but you're welcome to test your reverberations as well.
On the screen, it does not show a muted mic, but testing.
Okay.
But I've gotten, you don't have a mic. Right now, you're not connected via audio. So if you were hoping to play audio, it's not going to happen. Your video only. The only mic pulsing and open is the podium, which is how we want it.
Well, and just, you mentioned video. I mean, we just did that little experiment. I can move the video with my fingers. Everybody good with that?
However, you can make it move by flipping pages in a little.
That's fine.
I'm
Yeah, I can flip them real quick on the corner of the dictionary.
Yeah. Okay, you're ready with your next witness once we do get started?
Yeah, Ms. Nykerk's not available for a little while, but we're ready to move forward.
Okay. Do you envision her being available today?
Yes,
Okay, who are you calling as your next witness?
Mr. David.
All right, Mr. David, you should stay right there. Not time yet, but you should just be ready to go. You'll be called next. I guess then we can be at ease until Mr. Williams comes back.
Do you mind if I ask a question? Because I know we briefly discussed if Randy were to call somebody on cross, Casey then would have the opportunity to, if she wanted to do direct then or do it later.
Yeah, or both, as long as she's not repeating herself, time to.
Okay,
And you also,
Well-
you're not prohibited from, if you ask questions of a witness, regardless of who calls that witness, if you then want to call that witness later on, if it's for different subject matter, if it's for the same, the jurors aren't going to like you. I'll still like you, but the jurors won't. But I'll probably say you can't. Why are we covering the same topic? You had an opportunity and you began your examination of this witness on that topic, and yet you're doing it again.
which is why I was thinking about it. And so in planning ahead, how to
Okay.
be efficient, and everybody likes me. So my thought about
Don't go too
that,
far.
I know, can't win them all. But I feel like for me and considering my limited scope of what I'm doing,
Mhm.
it wouldn't be appropriate in my thinking of efficiency, not appropriate in just inefficiency sense until there's a full, complete direct. That's kind of how I was thinking.
That's
about
fine.
it.
Like I said, you won't be precluded from doing it because you have a piece of case that you're entitled to present structurally
Mhm.
after the Davids have presented whatever they're presenting on their counterclaims. So I would turn to, I won't say to you personally, but I'll say, is there evidence that the folks are going to be presenting in connection with the counterclaims that hasn't already been presented? And that can be any number of topics that are germane to defending against the counterclaims that weren't already covered.
And if I were to wait until full direct, I can then address everything that's been testified to.
Right, if you didn't already cover it in examining a witness, correct?
Fair enough. I think that's the cleanest way to do it.
Judge, if we have 2 minutes, I'm gonna take advantage of the 2 minutes and hit the little boy's room.
Sure, go for it. Your timing is great, except Mr. Edwards said, hey, since Mr. Williams isn't here, I'm gonna leave. He'll be back in a second.
Thank you, Judge.
Appreciate it.
We gotta go to 6 today.
As long as the jurors will let us go, if we get if, for example, the plaintiffs rest at 5:30, we'll just stop there. That's an actual great point. Not that I'm encouraging them to take that long.
All right. That's it. She understands. She's not here.
No, I think I thought we had talked about it. When we have the witness on Zoom, if you want to relocate to
Oh,
be
that's
directly
right.
in front of the screen, even though your back will be to the jurors, I'll explain that.
Okay, okay.
Because your equipment profile is very small, I think you'd be able to be over there. And the good news is it's not a particularly lengthy witness.
Okay, yeah, they said, like, okay. Yeah, this is important. Hold on, I'm not really checking. I gotta close this.
All right, let's get on the record. We've got everyone and we are ready to go in the Andersons versus the Davids. We are still in the midst of the presentation of plaintiff's case on Wednesday afternoon. All our jurors are here. Mr. Edwards, anything we need to discuss before we bring our jurors back in?
No, sir.
Ms. Sturm, anything from the defense side?
No, Your Honor.
All right, let's get the jurors, please.
All right, jurors.
I'm gonna go in the back today.
Or exchange.
No.
George President of the County Court.
Thank you, Deputy Gordon. Everyone else can be seated. Good afternoon, ladies and gentlemen. Hey, great to see you, Judge. Welcome back to 9J. It's always interesting to see jurors on day 2, to see different outfits. Every once in a while, I get a juror who doesn't change clothes throughout a trial. He or she usually ends up being left way over in the corner. But thank you all for being here pretty much on time. We had to tackle a couple things before we could bring you out here. Just a refresher, we are in the midst of the plaintiffs, the Andersons' presentation of their case. They called witnesses yesterday. They have a few more witnesses to call today. One may be appearing via Zoom, in which case you'll see that witness on that big screen right there. If that happens, Mr. Williams, our court reporter, is actually going to move around and will be facing the screen so he can see the person who's testifying. His back will be to you. Otherwise, things will be as they were before. One thing we worked through before you came out here is that the touchscreen now should be working. If anyone needs to mark something on there, we don't have to get them up out of their seat and in front of that monitor. So we'll see how things go. And we will have a break kind of mid this session. And then we'll go a little past 5. It'll really, when we stop, will depend more on where we are with the flow. That doesn't mean we'll go till 8. I don't mean that at all. But if there's a natural break point at 5:20, we may not push all the way till 6. For example, if one side rests, there are a whole bunch of things the lawyers and I need to talk about when that happens that you don't need to be here for. So we'll see how it goes. All right. Mr. Edwards, if you would call your next witness, please.
So Jean-Noel David for cross-examination.
All right. Mr. David, if you would come on up, please.
Raise your right hand. You swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, self you got. Go ahead and have a seat. Can you state and spell your name for the record?
Yes, I'm Ronald David. Jean hyphen Noel David.
Mr. David, good afternoon.
Good afternoon.
Make sure when you're answering questions that you speak slowly. I've only heard a few words, but they came out quickly. And I make sure the court reporter is able to take all that down. Okay,
Absolutely.
great.
Good. Thank you, Mr. David. And also, I understand English is not your first language, but it is one of several languages in which you are fluent. Is that right?
Yes.
So if by chance I ask you a question and you are not sure of the word or what I mean, please ask me to rephrase it or explain it so we're on the same page, okay?
Yeah.
All right. And I'm just preparing for what I'm going to be doing in a little bit. So let me just pull up an exhibit that the jury has seen so I don't have to worry about sharing too much at this point. There, the preliminary plat. Now, Mr. David, you just were sworn in by the deputy to tell the truth, right?
Yes.
And you have been sworn in to give testimony in this case a couple of times, right?
Yes.
The first time is in your verified answer and counterclaim, right?
Yes.
Okay. And I'm going to show you a copy and hand it off to the judge. Here's.
Thank you, sir. I care.
I'm going to share a copy of it with you. I'm not going to introduce it in evidence, but I just want you to have it when I refresh, so we can refresh your recollection. Okay. So these answers to the counterclaim, if you flick over to the last page, and I didn't attach the exhibits, but the last page is a verification where it says personally appeared before the undersigned officer, a notary public.
Which page?
The very last page. Yes. Very last page. That's your signature on May 24th, 2021, correct?
Yes.
And you say, having been sworn, deposes and states that the facts contained in the foregoing counterclaim are true and correct to the best of her knowledge. That's a typo. It should have been his knowledge. But everything in the counterclaim, the factual averments in the counterclaim were true and correct to the best of your personal knowledge, correct? Okay. So what I'd like you to do is turn to page 9 of the counterclaim. Or excuse me, page 10 of the counterclaim. And there's an allegation in paragraph 9 about conversations that Diane Darby supposedly had with the Andersons regarding her uses of the easements. Do you see that?
Yes.
And you state in the counterclaim that Miss Darby notified the Andersons of the ongoing use of the easements and directed the Andersons not to interfere with the sole and exclusive use of said easements by the David property during their ownership of the same, right?
That's what's in it, yes.
And you swore that that was true and correct and based upon your personal knowledge, correct?
Yes.
Please tell us the source of that personal knowledge supporting that allegation in the counterclaim.
The source,
How do you know that to be true?
we've talked to the Darbys over time.
And Miss Darby confirmed to you that she had spoken to the Andersons and explained to them the exclusive rights of the easement to the Andersons.
It was conversation between my wife and I, and I remember the Darbys were around. Yes.
Okay. That's fine. Paragraph 29 of the counterclaim, which is a few pages back, about top of page 14. You say, defendants installed a spike fence.
I'm sorry, defendant Stahl, go ahead, I'm sorry.
Defendants installed, meaning the Andersons, counterclaim defendants. This is for your counterclaim. The defendants, or the Andersons, installed a spiked fence along the border with the David property, which appears to be constructed to close the property line and potentially encroaching on the David property. Now I want to focus on spike fence. Explain to the jury what you meant in May of 21 when you used the term spike fence.
Offensive?
Offensive? Now, you remember I took your deposition in this case, right?
Correct.
And you explained to me in your deposition that spike fence is not a term that you use, correct? You remember that?
I remember that.
So in the counterclaim, was that your term, or was that a term that the lawyers put in there and you signed off on it?
My wife explained that term to me.
So it wasn't based on your personal knowledge, it was based upon your wife's personal knowledge.
But wouldn't
I
it
don't
be his
understand.
personal knowledge if she explained it to him?
Well, if my wife explains to me that she went to Kroger, do I have personal knowledge she went to Kroger?
Your wife,
All right.
to you.
So that's not a term that you use, that's a term that your wife used.
That's a term that I've heard in the past, yes.
Okay. Now, let's talk a little bit about the history of some of these confrontations that you have personally had with Mr. Anderson. Regarding the trash, you had a person, you can put that down. Actually, I'll take it away if you don't, because we're not going to use it anymore. I'll put it right here in case it's You had a discussion with Mr. Anderson about the trash in the dumpster, correct?
Correct.
And you went over and rang the doorbell and walked around and he was cooking hot dogs on the grill. Is that right?
I don't know, it was hot dog.
He's cooking something on the grill.
Yes,
And you spoke to him about the trash, right?
correct.
And he explained to you why he did that or why it was done, right?
Well, no,
He did not.
he did not.
What did he say?
He says my son-in-law did it.
Didn't give any explanation about the trucks.
It'd be easier if your workers don't park in front of my trash can.
And what was your response?
I'm sorry.
Okay. And did it happen again after that?
What happened after that?
Did trash continue to be put in the dumpster by the Andersons or their relatives after you had that discussion with Mr. Anderson?
I don't know.
Okay. So as far as you know, you deny that that issue was resolved with that brief, short interaction between you and Mr. Anderson, right?
I'm sorry, I don't understand the question.
I'll move on. The fence, the spike fence, you objected to the spike fence going across the easement area, correct?
Correct.
Did you object to Mr. Anderson directly or to someone else?
No, it's the worker that was on the, that was doing the work.
Okay. And that was resolved, was it not?
Well, they stopped. Yes,
Okay.
yeah.
So it was resolved.
Define resolve?
Is there, this morning when you got up, was there a fence of any type
On easement two?
on the easement too?
No,
So at least as of today, that issue has been resolved. True?
right.
Okay. And the sod issue, that was an issue that your wife raised, right?
Yes,
You did not raise that issue with anyone, did you?
there is sod on the easement too.
Well, and have you measured that so that you can tell us, Mr. Edwards, 24 square feet of sod or 10 square feet of sod or whatever is on easement two?
I have not measured.
Okay. Can you give us a ballpark? Is it 1 linear foot into easement two, or is it 20 feet, or what?
I don't know, closer to 1 to 2.
Okay. In all this time that we've been litigating this case, and all the money y'all have spent on experts and other things, have you hired an engineer or surveyor to go out there and say, I have measured the easement and the sod encroaches by X feet?
I have not.
Okay. So that's your opinion that it encroaches onto easement two by some undetermined amount?
No,
It's not?
no,
That's not your opinion.
it's not.
Whose opinion is it? Where's that coming?
It's the survey of the easement.
Who did the survey?
McClung?
Sorry, who did you survey?
McClung.
Oh,
McClung. Sounds about right?
So Mr. McClung has in fact surveyed easement two and reported that X number of feet of sod encroach upon easement two.
No,
We're not connecting here.
currently.
Other than yourself and perhaps your wife, are you aware of any other person who's going to come in here and tells this jury that X feet of sod encroaches on easement two?
If they have the survey in front of them, yes.
Who has done the survey?
No,
Well, the question is specific, not a general survey. Did he do a survey to determine how much sod encroached on easement two?
he did a survey on the easement.
I understand that, and that's not my question. Did he perform a survey of the easement that says X number of feet or inches of sod encroaches on the easement, yes or no?
No,
Now, I understand that you used to like, before any of this clearing and grading and all of that stuff allegedly happened, you would personally use easement two for ingress and egress for things like your morning runs, right?
yes,
And let me go to what was introduced yesterday as Exhibit 13.
can't see anything here.
It takes a second to sync up.
One second.
Maybe
What is the,
it says, do I need to unmute or anything?
don't do unmute. So if there's a stay mute, what are the two choices?
Stay mute?
Stay
and-
mute, hit that one. And then
Got
what's
it.
the,
Got it.
got it, you got it. And now, excellent. Thank you for flagging.
Thank you.
All right, so I'm sharing my screen, and during this morning, we figured out how to at least move the video. I can move it with my finger. And you recognize this as a video of the frontage of easement 2 taken on August 12th, 2021, of where easement 2 fronts on West Andrews, right?
It's a portion of it, yes.
Okay. So we see, do you see just kind of to the upper right from where the start arrow is, a blue ribbon?
I don't.
See right here, a blue ribbon?
Looks yellow to me.
That's a yellow
Oh, yeah.
power line,
Yes,
and to
yes.
the right is a blue ribbon. That is the south edge of easement 2, correct?
Yes.
Okay. So what I'm gonna do, and I believe you have a little highlighter there that you can use on the screen and touch and highlight something. So what I'm gonna do is I'm gonna move this along slowly, and you tell me when to stop when you see the path that you used on or before this day to access West Andrews for your morning runs. And if I skip it, tell me to back up. Keep going. All right, we're getting close to the end. Did we see the,
You skipped it.
I skipped it. All right, we'll start over.
It's something.
Tell me when to stop.
I go up anywhere here or on there. I
All
go
right.
back up anywhere or on there.
All right, show us, use your little red touchy thingy.
Move it back a little bit when he said,
Right there.
Yeah.
Okay.
I
Now,
can.
the way this, it's a little blurry now, but the way it works, if you tap the screen once, there should be a little pencil in a circle over on the left, lower left corner.
I see, lower.
Deputy Gordon's gonna show you how to do it. It works now, so we'll get this to work. Well, just don't press anything now. It may give you a strong electric shock. Okay, now, is it working? Oh, this guy was just here.
That's not working.
You know what I bet is it's this funky app that's
It probably is.
not going, but it's still going through Zoom.
Well,
Come to the big
I mean, I can
screen.
show them.
come to the
Yeah.
screen.
And I'm gonna get tech to show up now while we're doing it. Thank you, sorry.
Cause it was a pencil, now the pencil gone.
Yeah.
I go up anywhere here.
Okay, so through all this, you walk through here to get on and off West Andrews.
That's correct.
Okay.
Could go anywhere here.
And you remember I asked you, I did this same thing in your deposition. Do you remember that?
Can I go back sit? Or
Please.
go back sit?
Please, use whatever you're more comfortable with. We're not gonna be doing this again for a little while. You remember I asked you about that in your deposition and we did the same thing and you couldn't tell me where you were able to access West Andrews in your deposition. Do you recall that?
I don't remember that.
Okay.
Stop for a sec. Yes, ma'am.
I think he's backwards in his use of deposition transcript to
Right.
talk with the witness about it. I'm sorry, he's testifying from the deposition as opposed to asking the witness.
Right, so I want this to work smoothly. You may be calling Ms. David as well, and you may want to use deposition transcript, but you need to ask a witness a question, and if his answer is somehow inconsistent in your mind with the deposition, then we can go there, as opposed to, I'm gonna already get you with a deposition answer, unless what he just said, I don't know that it was, is inconsistent with a deposition, but you still show him that deposition information first before you wield it.
All right. Let me go to plaintiff's exhibit 22, which was admitted yesterday. These are the Google Street View images that Mr. Anderson identified. And if we go to the fifth page of exhibit 2, let me make this a little bigger and I'm going to call out the date. This is from November of 2019. So this is 5 months before y'all bought the house, right?
Yeah, it's 4.
4 or 5 months before you bought the house. Okay. And did the frontage of West Andrews at the time y'all bought it, did it look like this or did it look more like the video we just looked at?
That looks like that.
Okay, it looked like this. So can you, let's try that little red thingy again. Can you tell me, let me just call out all of the, what appears to be the frontage. Does this basically encompass all of easement 2 and then maybe some additional on the frontage?
This is part of easement 2.
I'm just talking about the frontage. I'm not talking about the back portion.
Oh, it looks like it.
Okay.
Yeah.
Can you use your little red arrow thingy and kind
The
of,
arrow thing is not working right now.
well, it wasn't working on the video, it might work.
Okay, well, try.
Let's try it. Try it again. And if not, we can come, you can come
But
around.
I have some in IT, because I would like it to work, so you don't have to keep doing what you're doing.
I appreciate that.
Yeah.
It's not working? All right, well, come here and show us where on this Google Street View image, you would come through here to do all of the.
Don't come up on you.
Okay, so you come through any of this brush, and would you have to kind of
No,
part ways, you just walk straight through?
yes, sir.
Okay, thank you. Now, you have that big notebook in front of you. Can you flip to tab 23?
Yep.
Do you remember we went over this in your deposition? It was actually marked, I'll represent to you as marked as Exhibit 2 in your deposition. And if you need to look at the Exhibit 2, we've got a copy in black and white. Want that? The black and white version of what we use in your deposition. If you want to kind of compare this page by page with plaintiff's exhibit 23, we can do that, or I will offer it right now and see if Ms. Stern has an objection.
Which, you
I'm
mentioned
offering-
a bunch of numbers, which one are you now offering?
I'm offering plaintiff's exhibit 23, which is a color version of what I just handed the witness.
Got it. So plaintiff's 23 is not yet in evidence.
Correct.
Okay. Any objection to plaintiff's 23?
I'm unclear if this is duplicative of what we're already admitting with our videos and pictures.
You're not testifying, you're explaining what is the origin or provenance of 23? Is it screenshots from videos?
Screenshots from the videos, and then there's also some pictures of their house taken from the real estate listing and some Google Earth images. So some of it's, well, I wouldn't say a screenshot is duplicative of the video.
No, and some of them aren't screenshots because I see, I don't know if it's Mr. Anderson's hand, there's a lens of a camera.
That's Mr. Elrod's hand.
Mr. Elrod's hand, okay. Regardless of whether they're duplicative, any objection to plaintiff's 23? I don't think there's an issue having a still version of what's in a video, but there may be stills in there with which you're not comfortable. And if there's an evidentiary reason, let me know.
No, Judge, I will say I'm a little bit worried we're headed down the same path with the deposition testimony.
Okay, we're not there yet. So
Okay.
no objection to 23, it's in.
All right. I'm now sharing my screen with you and the jury of Exhibit 23. Whoops. Make it a little bigger. Come on, cancel that. Go here. There we go. To the right, we see the fence kind of down the lower left-hand corner, right?
Yes,
And that's the spike fence, right?
yes,
Okay. And to the upper right of that is your fee simple property, right?
yes,
And we got some nice landscaping around here, right?
yes.
And cancel that.
You're showing off how you draw on screens.
And I
Can't
did,
do it.
and I did that with my right hand, and I'm left-handed, so. And also we have some nice lawn to the right, correct?
Yes,
And we have sports net of some sort at the end of this lawn area, correct?
yes.
What's the purpose of that sports net?
It's a soccer rebounder.
Okay. And the next page is an image of easement 2 taken from the drone, correct?
Yes,
Okay. And that also has a sports net. What's the purpose of that sports net?
it's a net you put in the back of either lacrosse or soccer, to catch the ball.
Now, kind of circling back to where I was a minute ago, when you would leave your house to go onto West Andrews for your morning runs, let's go back to the first page, would you, let me use my laser pen so I don't have to, would you go this way through the grass, or would you come this way down this little walkway and then through the wildlife and then turn left at the easement?
Anyway,
Both of them.
I rarely come to the left. I usually go to my grass.
Okay. So then you'd get to the grass and you would take a left and go through easement 2. And this path wasn't here until mid-August, correct? This path has been cut through.
Yes,
Okay. So you would,
but that's not necessarily the way I go, that you pointed at.
okay.
Okay,
So before the path was there, you would basically go anywhere, right?
right.
Okay. And then you would start your run?
Yeah, I'll either start or walk up Habersham or walk down towards West Paces, however I feel that day.
Okay. And for a while, you used to use Strava to track your runs, correct?
Correct.
And one of the features of Strava, it's like the Garmin app I use for my bike rides, it will map your run, correct?
Yes,
Yeah.
ma'am. Hold on one second. Yes.
Yes.
Again, he's testifying about certain characteristics of things. I think he needs to ask the question to.
He has the witness on cross-exam, and if Mr. David didn't use Strava, if I'm saying it correctly, he could say, I never use Strava. So I don't, come on in, please. This is I will make the screen work, gentlemen. So overruled for now. If I hear testimony, you think you're hearing him testify, let me know, but I think these are appropriate cross-examination questions. Can you please help us get the notation to work on that screen? That screen right there. It was working before your colleague was here and it worked. He left and now it doesn't work. Love for the witness to be able to mark it up. Does it ever matter the software that the person is using who's sharing? It shouldn't, because you're just touching on this. Shouldn't matter what application is running.
No, this
Should just be touchable.
As long as it's sharing, then it should.
Yeah, which is what's happening.
I'm about to look at it now.
You're doing what to it?
You reboot it.
Rebooted.
Oh, rebooting. Okay.
Okay, sure. Want me to share again?
When you shared earlier, it was from the same device or was it a different device?
When it was working when Cleveland was here, I don't think it was his funky device. Okay, well,
I'm just
you
not-
should use your device. My point is not use a different device. It just means that this is a first for me. But there are devices where it apparently makes that touchscreen for which Fulton taxpayers pay a great amount, not work. I don't want to delay things more. Maybe you guys can do a little research because what are you using an iPad with what on it?
It's called Trial Pad for iPad.
Trial pad for iPad. We need to be able to support that. You can't be the only lawyer out there using it. So
Probably not.
let's do a little research on that, not for today, apparently. And you're thinking that if another lawyer shares it the way I've seen it, like they're just putting a PDF in there, that should be fully markable. Okay,
Especially if it was working.
well, Cleveland said it was working.
Yeah, I know.
Okay, all right. See ya.
All right. Before we get back on the Strava stuff, I want to kind of go back to where we were a minute ago, talking about the sod supposedly in the easement. These are stakes and ribbons that you placed in easement 2, correct?
Yes,
And you placed them on the edge of easement 2, not a couple of feet inside easement 2, correct?
actually, I put them on easement too.
Okay.
When you say on, meaning you knew where the border was?
Yes,
So you purport that where these are would actually mark the border. If you're on one side, it is
still the
Anderson
easement.
property.
No.
No.
If you go on outside, if you're on the other side of the border, I mean, the ribbons, you're still actually on easement too.
Okay, so this would be a reason why you might say, I'm not saying it's correct,
It is
but you might
correct.
say there is sod in easement 2.
That is correct.
Because you're claiming that this ribbon isn't right at the edge.
That's correct.
There's easement 2 space beyond.
That's correct.
Okay, that helps
Yes,
me. Thank
Judge.
you.
So I have my little laser pointer here. You're saying that the actual border is on this side, somewhere in this sod area.
Somewhere, yes.
And that's your personal opinion based upon your review of the survey, correct?
Based on the survey in my hand, looking at the survey, looking at the ribbons and the peaks, the perks that are put on the ground, and yes,
And we didn't go through your educational background. You're not a land surveyor, correct?
I am not.
You're not a licensed engineer in the state of Georgia, is that correct?
Not.
Okay. So circling back to where we were, if you can flip over to tab 47 and 48 in that notebook.
Yep.
Do you recognize 47 and 48 as screenshots of your Strava profile that we talked about in your deposition?
Yes.
Okay, Your Honor, we offer 47 and 48.
Ms. Sturm, any objection to 47 and 48?
Your Honor, my objection to 47 and 48 is if we can stipulate that this is, we're using an app. And so just like we would calibrate something else, the calibration, we have no idea what the calibration of these are. We have.
So you're free to examine, Mr. David on this. The question is, it's got whatever, evidentiary weight it has. There may be reasons why this is just an estimate and maybe reasons why this is precise to the millimeter. And you're welcome to explore that with the witness. Do you have any objections as to foundation or its hearsay or anything like that?
Well, my objection would be to foundation, and that kind of gets to the issue. I
Would you like to voir dire this witness on this exhibit before I decide whether to admit it? Well, don't put it on a screen yet.
No, I'm having to show
Okay.
you.
I think while she's looking at, this is the same thing, just rotated. These aren't two, I don't believe, they're two different events.
One of them's, it's the same run. One of them
As
is,
long as
a-
you agree with me, it's the same run. I don't have an issue
it's
with
the
it.
same run. The second one is a more close-up image,
Okay.
Randy, can you tell me those numbers?
47 and 48. And let me just lay a little more foundation.
Why don't you get started on that?
Now, we talked about these in your deposition. Do you recall that, Mr. David?
Yes,
And in fact, we went through every run that had been recorded on Strava under the Jean-Noel David profile in Buckhead, Georgia. Do you recall that?
yes,
And this 47 and 48 is just one run. 47 is a bigger image and 48 is a close-up. Is that right?
I guess, yes.
Okay. And that trail, you recognize that route as a route you take very often, correct?
Not necessarily.
Well, it's a route that you used to take very often at the time I took your deposition. You may have changed since then, but that's the route that you took very often.
I did.
Okay. And that accurately reflects your route, correct? At that time?
Yes,
Okay. Your Honor, I think I've laid a foundation. I think we can move on.
Any objection based on those questions?
No objection.
All right, 47 and 48 are admitted.
47, this is the one we're just talking about, and this shows your run starting on Habersham, going down the road, turning onto West Paces, and circling around. It's a little under 3.2 miles, correct?
yes,
And your average pace is 8:47, and you told me your deposition, it's now down to 8:10 a mile, correct?
yes,
And I tip my hat to you for doing so well. Do you recall that? And the next exhibit is more of a close-up image, and it shows elevation or something like that. This is 48 I'm looking at. Let me do a call out here on 48. What we're looking at is where you start and end your run, correct?
yes,
And I understand that, of course, the app doesn't start until you press start, correct?
right.
And then the app stops when you press stop, correct?
That's my understanding.
And I believe that you said that you would use West Andrews for either ingress or egress about every other time, correct?
Pretty often, yes.
Okay. And this start and stop point is directly across from the end of your driveway, correct?
On Habersham,
Yes.
yes,
Okay. So whether you use easement 2 for ingress or egress, basically what you would do is you would walk out the house, you'd come down here, cross over, go up West Andrews, cross Habersham, come back down here, and hit start, and then start your run, correct?
I will hit the button start right there at the green light, yes,
Okay. Or if it was, you used West Andrews after your run, you would basically go out your driveway and then just reverse it. You would hit stop and then go back up the road, down West Andrews, across the easement, through your backyard, up to the house, correct?
sounds about right.
And in our review of all of your Strava runs, we never found one single run that covered any portion of West Andrews. Is that right?
I guess you did not.
Now, at some point, you decided to put a chair on easement 2, correct?
Yes,
And that has already been admitted as plaintiff's exhibit 6. Let me share that with the jury. Hold on a second. There it is. Plaintiff's exhibit 6. That's the chair that you put on easement 2 for your post-run recovery, correct?
yes,
Okay. So, kind of circling back to where we were, what you would do is you would finish your run, go back up Habersham, down West Andrews, come across these, down West Andrews, across easement 2, but you wouldn't stop at the chair. You would actually continue into your yard, back up to your house, get coffee, come back down your yard, cross into easement 2, and then sit there in this chair and enjoy your coffee and check your emails and whatever's on the news on your cell phone, right?
what's the question? I don't understand the question.
Okay, well, you would sit here after your run, correct?
I have sat there after my run, yes.
Okay, and you would sit there with coffee, correct?
Sometimes, yes,
And you didn't have a coffee pot out here, you had to actually go into the house to get the coffee, right?
yes,
Okay, so you would have to go into the house to get the coffee, and then you'd have to repeat this whole process. You'd have to walk through your backyard into easement 2, sit there and drink coffee, correct?
yes.
Okay. And if we go back to 23, hold on a second. Let me. So here's, on page 30 of exhibit 23 is a view of your backyard, correct?
Yes,
Facing the house.
yes,
And you've got a nice brick stairwell, and off to the left here, we have a nice brick patio, correct?
yes,
But instead of sitting there and drinking your coffee, you would go all the way through the yard, through the woods to easement 2 and sit there and drink your coffee, correct?
sometimes, yes.
Sometimes. Now, it wasn't your idea.
Unmagnify the picture for a second. I have a question for Mr. Duggan.
Yes, Judge.
I need the picture. There's a structure over on the right. Is that your garage or is that some part of the Anderson household?
Anderson House.
What part of their house is, I don't mean for you to tell me what room. Is that part of the main building or is that a garage?
That's the garage,
Okay. I'm just trying to see how close together things are. Thank you.
totally.
Now, just to clarify, this red brick structure, is that your structure or the Andersons' structure?
Nice house.
Okay. And the Andersons' garage is the wooden structure to the right, correct?
Yes,
Okay. I just
What is
want,
that brick structure? A little temple?
it's a shed.
A shed? It's a nice looking shed. All right.
and here's let me show you, page 28.
It's right here to the left.
This is the shed, correct?
Yes,
And actually easement 2 kind of, well, let me go to another page. Whoop, clear. Clear that, come on. All right, I have boogered it up. Now we've got technical difficulties here. All right, pen, highlight, I'm frozen. Basically easement 2 covers a good portion of the lower left of this picture, correct?
sorry.
There we go. All right, Judge, it seems like technical difficulties are an infectious disease in this building, so.
Going backwards from that screen to you.
All right. Let me stop my share, start over, see if this helps. There we go. All right. There we go. So what I was trying to do was show, and now it's frozen again. Turn that off.
So if you have those exhibits as PDFs, you can certainly share them in the good old fashioned way, just through Adobe Screen Share, and then,
All right, let me,
you'll be able to mark them up. I don't know what format you've got.
all right, Mr. Logan, can you share your content? And we're on exhibit 23. We'll do it the good old fashioned PDF way. One free. All right, we have to rotate those. I wanted a picture of their driveway and the shed from the front. So that's going to be down around 28 or 30. Here we go. Now down here in the lower right, Eric, you have rotate, that rotate option. Go ahead and go up to page 27. Yeah, and then rotate the document. Down lower right-hand corner. No, lower right, that's it.
Yeah, okay, yeah, they changed it.
Okay. So page 27, what we're looking
Try
at,
something before you ask your question. Now try tapping the screen somewhere and see in the lower left-hand corner is a little circle with a pencil.
Yes.
Now pick a color. Is there a little palette?
Yeah.
All right, now try circling your shed. Did it create on your screen a circle? All right, Deputy Gordon, can you?
But I can.
Oh, it did.
That's me.
Okay, look,
There you go.
It is green, it worked.
Hey.
All right, so that's how it works.
All right. So
Hold on, one last thing. You can erase it by hitting that, there's a arrow that looks like it's going in reverse. If you tap that, that should make what you did go away. So there, sit it once. Good.
okay.
I'm sorry, back to you, Mr. Edwards.
So now this is a picture basically taken from easement 1 facing the back of your driveway and shed and backyard, correct?
Yes.
Okay. And we see that kind of gate there between the 2 brick columns. That's basically the line for easement 1, and it's going to come kind of diagonally from left to right to the bottom of the screen. Is that right?
Wait.
All right, well, you draw it for me. Show us where the boundary line for easement 1 on the left and your property on the right.
Easement 1 is right here. Okay. Easement 1 right here.
Okay.
Okay.
Okay. And one of your planned or contemplated uses for easement 2 is to extend your driveway all the way down to West Andrews, correct? Through your,
We've talked about a lot of things. We're not even in the house. We're talking about a lot of options, you know. So we talked about driveway, we talked about a lot of things.
but that's specifically one of the things that you guys have contemplated is to extend your driveway and use easement 1 for access to West Andrews, right?
We've talked at a really, really high level.
Okay.
Yes.
So to do that, you'd have to tear down that shed and cut down all those trees and,
There's professionals that tell you how to do that.
okay. But y'all haven't actually gone that step to talk to a professional as to whether we're gonna do that.
We have not. It was, one conversation with Cheese.
Okay. Eric, if you can pull up, do you have defense exhibits on there? No. Okay. All right. Do you have this, no, you don't have that. Well, that's not it. The fence along the border, the common border, the wooden fence, that's about 120 some odd feet long. Is that right?
It's less.
How much less?
It's about 90, between 96 and 100,
Okay, so it's still 30 yards.
I guess so.
Okay. And the chair, did I ask you, oh, I asked you this, I don't remember. Your wife is the one who recommended that you put that chair on easement 2 for your post-run coffee. Is that right?
We just talked about it one day that I like to sit there for my coffee and says, why don't you just take a chair? So that's a great idea.
Okay. So your wife is the one who recommended that you take that red chair out there?
No, she did not recommend. She just offered the option. Plus, I don't understand the word.
All right, I got to do this old school way since my iPad's not working. Oop. Remember, I took your deposition on January 27th of 2022, right?
Yes, sir.
And what did I say? 78. Page 78, I asked, who suggested you take the chair out there?
Oh, yeah, yeah. You remember my English is my third language. So I'm sorry. Yes, we talked about it. She offered the option. If you call it the recommendation, yes. Yes.
Well,
I just remember English is my third language.
I understand that.
Okay.
You didn't raise that issue in the deposition in response to this question, though, did you?
I don't remember.
You said on page 78, line 4, someone
So
told me.
let him read it and see if that refreshes his recollection,
Okay.
and then you can ask him to explain the discrepancy if there's a discrepancy.
Yes, I read it.
So you told me under oath in your deposition that someone recommended that you put the chair there, and then when I asked you who, you said my wife. Correct?
Yes.
Now, we started, when the lawsuit was filed, those ribbons and stakes were not along the easement line, were they? When approximately did you put those stakes and ribbons up to mark the easement area?
I don't remember exactly.
It was definitely after the lawsuit was filed, right?
That's correct.
And why did you do that?
Well, one of Mr. Anderson's complaint was for people to walk up his property. So putting the ribbon will delineate the separation between his property and the easement. And I have kids that actually play out there. I want to make sure they don't cross over Mr. Anderson property. So they see it.
And you mentioned people would use the easement for ingress and egress. The workers on your house would use easement 2 for ingress and egress, right?
I did not say, the easement, yes.
Would use the easement.
Yes, easement.
What type of stakes or ribbons or marks did you put up to show the workers the boundaries for easement 2 so they wouldn't go around the rest of the property?
At that time, we did not.
And we saw the area, you showed us the area where you would enter easement 2 from Rest Andrews on your runs. Do you know exactly where these workers carrying the tool belts and other equipment would enter easement two?
I don't.
And at some point you put the nets up, right?
Yes, sir.
And you had some friends do some clearing.
Yes,
And those friends, do you know their names?
I do not.
And do you remember another time when you answered stuff under oath? In this case, were interrogatory responses. And you understand, and interrogatory is a written question that we send to your lawyers, and y'all have to answer it under oath. You understand that? Okay. One of the issues we've tried to figure out from the start of this case was exactly what uses y'all wanted to do on easement two. Do you recall that?
I recall the question, yes.
Okay. And actually, if you look at interrogatory number 14, which is at the bottom of page 8, and the answer is at the top of page 9. So we asked you, interrogatory 14, describe with particularity your current plans for the use and or improvement of easement 2 in the future. And the answer was what? I'll skip through the objections. Your answer was, the Davids respond by stating that in the future they intend to make.
Objection.
Stop for a second. Yes, ma'am?
We've got a procedural issue again on how Mr. Edwards is presenting.
Judge,
He's testifying as opposed to the witness.
Judge, I'm going to ask the witness if I read that correctly, if that was their answer.
Okay. I assume that's how you were gonna end. You may preclude some of these objections if you say, was it not your answer? And then you read these things because there you've indicated the question in advance, but overruled.
Okay. Was it not your answer?
I like that.
The Davids respond by stating that in the future, they intend to make use of easement 2 in compliance with their legal rights to do so. Was that your answer?
Yes,
So you didn't give me any specific uses. We intend to do X, Y, or Z, did you?
No.
And if you look at the last page of this were served on us. These answers were served on us on July 6th, 2021, correct?
yes.
And were you aware of any back and forth between my office and Ms. Stern's office about, hey, we need a more specific answer as to what, if any, specific uses you currently plan? Are you aware of that?
I knew there were conversation, don't know the details.
Okay. So y'all gave us a supplemental response. And if you look at the back page, this was served on us on August 9th. Is that right?
But he says yes.
Okay.
Of what year?
Of 2021. Just less than a month later, approximately a month later. And if you look on page 10, the same interrogatory, there is a supplemental answer, correct?
Yes.
And if you look down at the bottom of the page and continue on to the top, the supplemental answer, I forget how I phrased the last one. Is it correct that your answer on August 9th was future uses of easement area 2 would have and may include maintaining it for privacy purposes, for enjoyment and peace of mind, for natural and aesthetic purposes, including as wood, for access to West Andrews Drive, and for any other purpose authorized by law, correct?
Yes,
And that was a full and complete and truthful answer on August 9th, 2021, correct?
yes,
So if you had intended at that time to put these sports nets up on easement area 2, that would have been included in this answer. Is that fair?
no,
Well,
I mean,
You can,
go ahead.
you can explain your answer.
Yeah.
I mean, if I want to go and put a soccer goal out there, do I have to send you a letter?
That's not,
You don't get to ask him questions, but maybe that was a
No, but that
rhetorical
was,
question.
I mean, I didn't understand the back and forth.
so
So,
here's, the question was, describe with particularity your current plans for the use and or improvement, wasn't ask us permission. We wanted to know specifically your current plans. Is that fair? I'll withdraw that. You can't say what we wanted. But that's the question we asked, for you to tell us specifically what your current plans are. And you gave us an answer. And this answer was also verified under oath,
yes,
subject to penalty of perjury, correct?
yes,
I'm not asking you whether you had to ask our permission. I'm asking you whether on August 9th, you actually had a current plan to put these nets up. Yes or no?
no,
So something changed between August 9th and August 12th. Let me back up. As of August 9th, did you have any current plans to have these friends come out and clear a path for access to the street?
no,
Okay. And you agree with Mr. Anderson that those events occurred on August 12th, 2021. Is that right?
if that's it says, yes.
Okay. What changed between August 9th of 2021 and August 12th of 2021?
I exercise my easement rights.
What made the light bulb go off in your head to say, hey, I've got an idea. I'm going to go out here tomorrow and put these nets up? What was the light bulb?
My kids,
Your kids. Were you aware of any discussions that Ms. Sturm and I were having or trying to have during that 3-day window about this case?
no,
Are you now aware, as we sit here today, of any discussions that Ms. Sturm and I may have had during that 3-day window between the interrogatory response, when you didn't tell us anything about the nets, and the nets popping up 3 days later?
So you can answer that question, but we're going to proceed with caution after that. You understand the question? Have you learned now that maybe back then your lawyer and Anderson's lawyer?
I
were
mean, I
talking-
know they were talking at times. Now, I don't have access to those conversations all the time. I don't want it. And so there was conversation, yes.
But specifically that 3-day window, are you now aware of any of those conversations?
Like, I mean, can you clarify aware as if you were talking or aware of the content?
Are you
Specific of the content?
Are you now aware of any emails that were exchanged between Ms. Sturm and I between August 9th of 2021 and August 12th of 2021 regarding your uses of easement area 2?
I'm aware there was conversation, yes.
Okay. But my question was, at that time, back when the nets are going up and the workers are coming out, were you aware of any email exchanges between Ms. Sturm and I? Are you now, as you sit here today, aware of any email exchanges between Ms. Sturm and I during that 3-day window about this case?
Yes, I am now, yeah.
Okay, you are now. And I'm not asking for advice. Don't want to know what, if anything, Ms. Sturm told you, but is it fair to say that if she gave you any type of advice as to what, if anything, to do, you would have followed it? Okay. And
You've skirted it so far. I'm listening closely. Don't worry, and I'm confident Mr. Edwards is being thoughtful. In fact, he has said, I don't want you to tell me what your lawyer said, so we're okay here.
And
I just let me let the lawyers know, there's nothing untoward happening here. Just what lawyers say to their clients and vice versa is in confidence, it's privileged. And so it is appropriate for lawyers to say, hey, did you talk to your lawyer about something? But not to get into the contents of that communication unless someone waives the privilege. Mr. David could say, I'm going to tell you all about it, but he'd have to say, I want to do that. He can't be compelled to do that by a question that he has to answer under oath. So we're in a safe space here, and Mr. Edwards understands the contours. That's just why Ms. Sturm has been levitating. Okay, Mr. Edwards, let's move on.
And it's your position that it's not just a 100% coincidence that those friends of yours were out there clearing the path on August 12th with these ongoing discussions. It's a 200% coincidence.
Absolutely.
Absolutely pure,
Coincidence.
pure, total coincidence.
Yes, sir.
Now, at some point, we inspected the easement area, we inspected the property, took a bunch of pictures, took these drone videos. You're aware of that, right? And you're aware that we had to coordinate that inspection with your lawyers, right?
Yes.
And you're aware that one of the things we were concerned about was making sure that there wasn't any altering of your property to create a path to easement area 2 that wasn't there before. Are you aware of that? Okay.
Yes, I'm sorry.
Okay. Your Honor, plaintiffs exhibits 24 through 39 are photos taken from the inspection. I would offer those.
What inspection are we talking about?
The inspection that occurred in the summer of 2021 that we just discussed with Mr. David that we had to negotiate with Ms. Sturm.
24 through 29?
39.
39, okay. Mr. David, if you could flip through 24 through 39 and let me know if you recognize those photos.
I'll try.
Yes, Judge.
You recognize those photos? Okay. Any objection, Ms. Sturm, to the admission of 24 through 39?
No, Judge.
They're all in.
Let me. I closed out my app and restarted it, and it appears to be sharing. So plaintiff's exhibit 24, this is a picture taken by Mr. Elrod during that inspection, correct?
Yes.
And we see, do you agree that there is a path? Let me use my laser. There's a path right here from your property, and it kind of turns. Maybe it goes on easement 2, maybe it doesn't, but it kind of turns to the south. Is that right?
Yes.
Okay. What's the purpose of that path?
The path.
It's a path. And plaintiff's exhibit 25 is more of a close-up of that path, the end of that path, correct?
Yes.
Okay. And would you agree with me that that path appears to be rather fresh the last day or two?
It fresh, I don't understand fresh.
Does it appear to you that this path has been freshly created either by a weed whacker or some sort of a cutting tool or something?
Yeah, maybe, yeah, it looks like there's a more naked area than others. Yes.
Okay. And do you recall explaining to me in your deposition that the source of this path was your son riding his motorbike or bicycle out there,
It's a mountain bike with his friend, yes.
mountain bike? Oh, here we go. And plaintiff's exhibit 26 is another image of that. Let me just keep scrolling through. Plaintiff's exhibit 27, this, do you recognize this as kind of a close-up of what we're just looking at 26? And do you see these fresh ivy leaves on the ground?
Yes,
Does it appear that they have been cut freshly because they're still green?
still green?
Yes.
Yes,
Okay.
yeah. They're still green, yes.
And you know that leaves, when they get cut off of the source, they die and turn brown and shrivel up. Correct?
Is that a question?
Yes.
Oh,
Do you agree with that?
and I'm not a specialist on
Okay.
this issue.
So this is the path that your son uses his mountain bike on, and he just goes to a point and stops, correct?
You'll be surprised.
Okay. But this is not an example of somebody, one of your friends, for example, going out there and cutting a path and then being told, wait, that doesn't go the right direction.
No, not at all.
Plaintiff's exhibit 29 is another close-up. Do you agree that the leaves here have been freshly cut within the last 24, 48 hours?
They're cut. Yes,
Plaintiff's exhibit 30, another example of a relatively freshly cut path into the
How
ivy.
many examples of freshly cut path with green leaves do we have there?
Just a few. Well, I think that's probably the last one. Well, let me just,
Let's move past the.
okay. 32, this is your property showing dead limbs and stuff like that, right?
yes. that
Is that what easement 2 looked like when you bought the property?
No, it was wooded area.
Wooded. And plaintiff's exhibit 33 is another angle of your backyard showing some sort of debris, correct?
Yes,
Plaintiff's exhibit 34, this is the view of the fence from your side of the property, correct?
yes.
And what is plaintiff's exhibit 35? What do we see here in your backyard?
It's a ceramic pot. Is that what it is?
You tell me. Here is a picture, plaintiff's exhibit 36. This is your brick walkway parallel to the fence, correct?
Yes,
And plaintiff's exhibit 37 is the same walkway, but from the opposite direction. There's a little stone sitting pad there, right? Correct?
yes,
Now, before the fence was there, if you would go this direction to access easement 2, you would continue walking all the way down to what is now the end of the fence before you would turn left. You wouldn't turn left here at this path, would you?
no, yes,
Because if you turned left here at this path, you wouldn't be using the Andersons, you wouldn't be using the easement, you'd be using the Andersons' property,
that's
correct?
correct.
And 38 is an image taken from easement 2 showing the Andersons' property, the fence, and the stakes and ribbons that you had installed, correct?
Yes, so the fence ends at the property line. That's where actually the easement starts. So that's where the grass is on easement 2.
So that extra, now how do you know the fence goes all the way to the edge of the easement instead of stopping a foot or two short?
Because I measured,
Did you measure it with a tape measure?
with one of those contractor measure that you use, that you buy at Lowe's.
Took a survey tripod and put it out there and it's got a laser light and you measured the time? So what,
No, not a tripod.
is that a stake just to the right of the stake that you have installed?
I have not,
No?
no.
Why didn't you put your stake up against the fence if that's the true edge of the easement?
In case my kids were playing, I want to give them an extra yard just in case, so they don't step on Mr. Anderson property.
And finally, Plaintiff's Exhibit 39, this is an image taken that day of the Anderson, from the Andersons' property, of the Andersons' property, going down the Andersons' property with easement to being outside the picture, correct?
It looks like it, yes, sir.
So if people were to have walked this way to get to or from your property or the Darby property, they would not be using easement 2, is that correct?
That's correct.
All right, we've also got a couple of drones, Plaintiff's Exhibit 41 and 43. Any objection?
Is it gonna be something new and different? 'Cause
It's going to be drone views of this. We can take a break.
I don't need a break. I'm wondering if it's something different.
It's a different angle.
Okay.
And perhaps,
Objection to 41 and 42.
Randy, are these the ones that were on the separate drive?
yes.
I don't believe so. Judge, I think that was a set of the ones we agreed to yesterday.
Okay.
Yeah.
They're admitted.
They're admitted, and I'm going to try to just kind of scroll through this real quick. We're looking at the edge of, well, we see the fence and we see your stake. Do you not agree that is a survey stake between your stake and the fence?
Can't tell.
You can't tell? Okay, I'm just going to scroll through this real quick. This shows some of the paths. That's the path that your son uses on his mountain bike.
Anywhere over there.
Okay, anywhere over there. And here's the net and the path that your friends cut in. All right, that's the end of that. I'm going to go now offer Plaintiff's Exhibit 43. Whoops, I'm not sure that yet. Oh, that was admitted, correct? Got it.
41 and 42, I thought?
43.
43.
Okay.
Okay.
Let me kind of scroll here. This is a more overhead view. You recognize this as West Andrews Street and the Anderson house on the right?
Yes,
And we see the fence kind of splitting your property and their property.
yes.
Okay, the drone flies down, pivots up. We see the net. We see, is that ground all wet and mushy? No?
I mean, when the sprinkler's on,
Okay. Then we kind of fly up along the fence, get a little better view of your property, and we see your net over here on your property, and then we swivel back to the net on the Anderson property. And do you have a preference for whether your son practices his sports on your property or the Anderson's property?
When you're saying Anderson's property, you're referring to easement 2?
Yes, sir. I should have clarified.
whatever works to make him better.
Okay, fair. Now that this is back up and running, I can go through your deposition. And let me look at the portions I was going to ask you questions about.
You take it down from a share screen.
Why?
Why are you putting the deposition on the screen?
So the jury can see it.
Why don't you frame a question for me before you put the deposition up so I can see if I agree? One, it's not in evidence, but two, so I don't know how it would be on the screen. You didn't put the complaint on the screen. It's not in evidence. You put the interrogatories on the screen. They're not in evidence. This isn't in evidence. So I don't know how it would go on the screen. I'd ask a question. First, take it down, please.
There, Chair. I have to show something. I can't go
Share's
blank.
great. why don't you ask a question that you want to ask about the deposition, and then I'll let you know if the jurors need to see anything as opposed to hear things.
Well, I will, Judge, but I'd like to respond to the objection. The rules of civil procedure say that the deposition of a party may be used for any purpose. It does not need to be offered into evidence. I can share it on the screen and go through it with the witness and highlight his questions and answers in real time.
Guys, you ask your first question, and I'll let you know if you can put the deposition up on the screen as opposed to have a copy for Mr. David to look at.
All right, let's do this. Let me stop my share so that, because I've got it annotated. Okay, that's not showing. Now, whole new line of questioning. Glad you did that, Judge. Because now I've got to go to the affidavit of Mr. Will, because I had some deposition answers in response to that.
All right.
All right, Mr. David, I'm handing you a copy of a notice of filing corrected affidavit, and it has an affidavit that you signed and verified under oath on September 13th, 2021. Is that correct?
Yes.
And again, you swear to tell the truth and that the facts contained in this affidavit are based upon your personal knowledge, correct? Okay. Flip down to paragraph 7 of your affidavit or declaration. You claim that Mr. Anderson has yelled profanities, made lewd comments, and verbally abused my wife, including in front of our children, correct?
Yes,
Did you personally observe that?
I did not.
How do you, so your wife told you, I take it, that he verbally abused her in front of your children, correct?
Yes,
Okay. And you say in here, he has likewise yelled profanities at me. Is that correct?
yes,
And do you consider yelling profanities to be verbally attacking someone?
yes,
Okay. Do you remember me asking you about whether Mr. Anderson had ever verbally attacked you in your deposition?
yeah,
And do you recall your answer?
yes,
You do recall, well, if it's true, if the declaration is truthful, your answer would have been consistent, right?
yes.
Okay. Your Honor, can I show the jury and Mr. David his answer to the question?
You can show Mr. David and see what he has to say about what the deposition says his answer was.
Okay. Let me hand you a page of your deposition and look at the question on page 75, beginning on line 16, going through 21.
From where to where?
Line 16, the question was, has he ever attacked you verbally or otherwise, correct? That's the question.
Yes,
And read your answer to the jury.
no. Attacked, no,
Okay. And then next question, has he ever attacked your children verbally or otherwise? Your answer was?
I mean, he's attacked, no,
Okay.
I'm sorry, Judge. Mr. DeVito.
No.
Pull your mic though to your.
yeah, I'm sorry. I'm so sorry, it's the accent.
It's also soft voice. We're understanding you. It's just,
Yeah.
you're distant from the microphone. So if you roll a little closer.
I'm so sorry.
And talking about the video where Mr. Anderson recorded you putting the net up. We saw that
Mhm.
yesterday. I'm not going to go through that process again. were you scared during that interaction?
Yes,
And you volunteered, do you recall telling me in your deposition that you thought he might have a gun?
yes, he could have anything. He is shown his behavior that unpredictable.
Okay. On page 75, line 5 and 6.
Which page 75?
75 right here.
Yes.
So-
Do you want me to read it?
Sure.
He's a big guy, and I know in this country we can carry guns pretty easily.
So there wasn't anything specific about Tracy Anderson, it's just this country, people have guns, right?
Is that the question?
That's what you told me in your deposition on January 27th, 2022, correct?
That's what I said, yes.
One of your criticisms of the Andersons is they did not consult with you before building that spike fence, correct?
That's one, yes.
You believe that they should have consulted you, right? Should have said, hey, we're building a fence, something along those lines, right?
I believe in good neighbors, you know, it's, if I want to do something that's going to be interacting with my neighbor, I will knock on the door and have a conversation about it.
Okay.
Yes,
But as far as putting these nets up and these ribbons and all that, it's not a two-way street. You can do that on a moment's notice with no consultation of Mr. Anderson, right?
I was exercising my easement agreement.
Okay, so the answer is, yes, Mr. Edwards, I can do whatever I want, and I don't have to consult with the Andersons about anything on easement 2,
So
correct?
that wasn't his answer. You can ask him questions,
All right,
but
let
you
me-
can't then comment on the answer he gave.
Let me rephrase the question. Is it your position that you do not need to consult with the Andersons about any of your intended or actual uses on easement 2, no matter if or how it may annoy them?
It depends.
All right, give me an example of the situation where you feel today that you need to consult with the Andersons before you do something.
Probably putting a fence, define consult.
Talk to them.
I mean, anything that will stay permanent.
Those nets, while they're technically not permanent, they've been there for over 2.5 years, right? Coming up on 3.
I'm not sure they're there today.
You're not sure they're there today?
I don't think I didn't check. But,
You heard-
but they're not permanent.
You heard Mr. Anderson say yesterday that they were there yesterday morning. Do you dispute that?
I just said I don't know.
Have you removed them since you got home from court yesterday?
I have not been on easement 2.
Okay, so if they were there yesterday morning, they're still there right now.
That'd be my guess.
One second, Judge. Thank you, Judge. Nothing further at this time. I reserve my right for further cross if and to the extent there's further questions.
Okay. Ladies and gentlemen, we're gonna take a break. And when we return, we'll see if there's any, it's a little backwards for Mr. David because he is, for the purposes of the Anderson's case, the opposing party. He actually started with a cross-examination. Normally it's a direct exam, and then what happened? What did you do after that? But it's reversed here. It was perfectly appropriate for Mr. Edwards to call him in his case in chief. The defense will have an opportunity if they want to ask questions of Mr. David. They will be the open-ended ones, not the leading ones. And so we'll see if they're gonna do that now. They could wait and call Mr. David in their case in chief, which would happen after the plaintiff's arrest. Regardless of all that, we're gonna take a break and reconvene in as close to 10 minutes as we can get you all back here, okay? Please don't talk about the case. Enjoy the jury room and the environs.
All right, Mr.
Yes, he's coming. I think the tire place is open till 6 or 6:30. Let's try to get it today. Would you put her in the kitchen?
All right, Mr. Edwards, anything before we break?
Yes, sir. Just got a text from Ms. Nykirk. She has just signed in to the Zoom room. I would greatly appreciate it if we could take her now out of order. My direct of her will take maybe 10 minutes. I don't know about their cross, but I would certainly like to get her up and down now. She's had issues putting her mother in a nursing home and all this stuff. I'd like to get her up and down.
So why don't you all talk during the break? I'm a little reluctant to not immediately follow up and let the plaintiff have a chance to ask all these questions and leave it the way they did, and then we don't hear anything from Mr. David in the other direction to accommodate Ms. Nykirk in yet another way, who's not here in person. So I'll let you discuss. If they agree, we'll take Ms. Nykirk then, otherwise she will wait until we're done with this phase of questioning Mr. David. I'll be back out in 6 or 7 minutes. Thank you. I didn't ask this side. Do you have anything before we break?
No, Judge, can you mute the,
Yes, let me mute the podium for reminding me.
Here's probably
It's either N-E-I, K-I-R-K.
okay, it's
maintain or cause to be maintained all improvements and structures in it elects to construct within easement area 2. Grantor acknowledges and agrees that grantor shall have no rights to interfere with grantee use of easement area 2. Want to read the rest?
Thank you, Mr. David. To your knowledge, are sports nets unlawful?
No,
To your knowledge, I'll call it a soccer chair, so to say, is that unlawful?
no,
To your knowledge, is walking across easement 2 unlawful?
no.
There were some communications or discussions with Mr. Edwards about an affidavit and some deposition testimony. Did your understanding of communications between those times change?
No,
Okay. Did you have subsequent interactions with Mr. Anderson that changed?
no. I mean, can you ask the question again?
Sure.
Oh, sure.
Did you have any interactions with Mr. Anderson subsequent to your deposition?
Yeah, I mean, yes. Yes,
And those included verbal communications
Yes.
from Mr. Anderson? Okay,
yes.
thank you. With regard, we don't want to get into your running history again. But we saw some drone footage, correct?
Yes.
Do you recall that site visit?
Yes.
Okay. Do you recall how long we were out there?
Oh, yes.
Was it more than an hour?
Oh, yes.
Was it more than 2 hours?
Oh, yes.
Is it more than 3 hours?
Yes.
Mr. Edwards asked you about a spike fence. Do you know the location of that fence as far as where it sits between your property and the Anderson property?
If I know if I look at the survey from McClung that is, and the spikes that the pickets that they have, it spots on the border of both properties, more towards on his property than ours property.
Okay. Is it 6 feet off the property line?
No,
Is it a foot off the property
No.
line? Okay, so does that change your opinion as to, or does that get to your opinion as to why a property owner might consult their neighbor about installing a fence?
I think they should, yes.
The location of it?
Yes.
Okay, thank you. I don't have any other questions for you right now.
Do you have any questions for Mr. David at this time?
Only just a couple at this time.
Okay.
Good afternoon.
Good afternoon.
Can you hear me okay?
Absolutely. correct.
Okay, thank you so much.
Sure.
So, and Ms. Stern was actually just asking you about the Anderson's fence, correct?
Yes.
Okay, and you said when you were looking at where the fence was, you eyeballed it, correct? On
I
the survey, you
I don't
looked at
recall
it?
using that words.
I thought I heard you say that. Did you not say that?
Eyeball?
Yeah,
I looked at the survey
okay,
from McClung and then at the spikes that are on the ground that they put when they come and survey.
okay,
And the spikes that they put on the property lines with the different colors of the ribbons. And that's how I know where the property line is.
okay. And I believe you said that the fence is on the Anderson's property, correct?
It's in, yes, if, yes,
Yes,
yes.
okay.
I assume that, yeah.
And a little earlier, you were talking about where the fence ends
Yes,
in relation to where easement area 2 is, correct?
yes.
Okay. Now, you wouldn't have any personal knowledge on if the Andersons actually decided to stop the fence short of where easement area 2 was, meaning not extending the fence all the way to the border of easement area 2, correct?
I don't understand the question.
So if the Andersons chose to stop the end of the fence on their property before it reaches the border of easement area 2, you would not have personal knowledge of that, correct?
No, I know that,
How would you know that?
because I asked the worker to stop at that point.
And he did stop, right?
Yes, he did.
Okay, and I appreciate you saying that. However, that's not what my question was. Did you understand my question?
Actually, I don't understand your question, so you
Okay.
may have to use different way.
Okay. You were looking at a picture, right, of the fence, and it came to an end. There was a little space, and then there was your ribbons, right? And the ribbons are about where easement area 2 starts.
Okay,
Should
yeah.
we put the picture up so we're not having to?
Yes, I understand now what she's talking about.
I think it's 32.
It's the 38, right?
But the one with the, whoops, move.
Yeah.
Yeah. Yes, okay. Remember this picture?
Yes,
Alrighty. So you see how the fence stops? It's got a little end pole right there.
yes,
All right. And then you keep on moving a little bit to the left, and then there's your ribbons.
yes.
Okay. So what my question is if the Andersons chose to stop that fence short, meaning it stops still on their property and not up on the border of easement 2, you wouldn't have any personal knowledge about that.
No.
You would not.
I mean, no,
Okay.
you never told me.
Fair enough.
Okay.
Right. Okay, thank you. And you said a moment ago, well, hold on, let me go back a minute. Would you agree with me that a fence could be knocked down?
Yes,
Okay. And when you put your chair on easement 2, you were able to put it there, right?
yes.
Okay, and were you able to sit on it?
Once, yeah.
Okay, did you take it back with you every time, or did you leave it there for a little bit?
I left it there.
Okay, you put the nets up, you were able to do that?
I'm sorry, repeat your question.
You put the nets up, you put the nets up, you were able to do that, right?
I'm able to do that. What is the that?
Put the nets up on
Yes.
easement area 2,
Yes, I did.
and you've left them there?
Yes, I did.
Okay. And I believe you said that if something's gonna be there permanently, but maybe even just for an extended period of time, that you should consult with your neighbor, that's being good neighbors, right?
I would assume so, yes.
Okay, but you didn't consult with the Andersons about leaving stuff up on easement area 2, right?
But if I choose to move the chair now, I can. If I go and choose to move the fence, I can today.
Sure, I mean, they could knock it down if they wanted to today, right? Right?
Yes, I guess, maybe. Yeah.
Okay. I mean, it's possible,
Everything's possible, yes.
right? But I mean, but you didn't talk to them about putting everything on easement area 2, right?
I was exercising my easement agreement.
Okay, so
Right.
were you trying not to be a good neighbor?
No, I've been a very good neighbor.
Okay. No more questioning.
All right. Mr. Edwards, anything else?
No, sir.
Okay, for now, Mr. Debbie, you're gonna step down, and may get called back when, your lawyers are presenting their case. Thank you for your time. Mr. Edwards, your next witness.
And Nykerk, hopefully by Zoom.
All right, let me,
Let me text her.
pardon me? Yes, you should move on over. Thank you. See if she is in, I can see her, she's gonna unmute.
Perfect.
Sure. Good afternoon, Ms. Nykerk, can you hear us?
Yes, I can.
Great, thank you for joining us and being patient. We're just getting the court reporter relocated, and once he's in place, then Mr. Edwards may have some questions for you, and we'll see if any of the other lawyers do as well.
Okay.
Ready? Okay, first thing is Nykerk Deputy Gordon is gonna swear you in. I don't know if you can see him on any one of these screens, but you'll be able to hear him.
Can you raise your right hand?
Yes,
Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lower your hand, state and spell your name for the record.
Ann Nykerk.
Can you spell your name for the record, please?
Yes, it's ANNE, and my last name is NEIKIRK.
Mr. Edwards?
All right. Thank you, Ms. Nykerk. Can you see me and hear me?
Yes, I can.
I see that my head's kind of shiny up here because my hair is going back further than it used to. We're here during the trial. I'm just going to ask you a few questions about your experiences with 3350 Habersham Road and the next door neighbors, 3350 West Andrews and the next door neighbors. Where do you currently live? And I don't need the address, just city and state.
I currently live in Charlotte, North Carolina.
Before that, where did you live?
I lived at the subject property, which is, I think we said 3350 West Andrews. We knew it as 3381 Habersham.
And how did that change?
We changed it before we sold the property because the driveway faced West Andrews, and we just felt it like it was a more logical address for the property, and just would function better that way. And it just took a little bit of time to get it all done, and so we ended up with selling it shortly thereafter.
Was the mailbox always on West Andrews, or did it used to also be up on Habersham?
It used to be on Habersham.
Okay. And how long did you live there?
We lived there almost 15 years.
From when to when?
We bought it in June of 2004 and sold, I think, in the fall of 2018.
Okay. And I saw you look off to the right and down. Do you have some notes with you?
I do. I have a copy of the affidavit that I submitted, and then I wrote at the top what I thought were the dates that we purchased and sold, but I'm not even positive those are right. But I think
Okay.
that's
Sorry, but I'm not.
Yeah, slow down.
But I'm not, repeat after that, please.
What did you say, Ms. Nykerk, at the end of your last answer, if
Okay.
you remember?
I was saying that I believe that we bought the house in June of 2004 and sold it in the early fall of 2018. And that I was looking at notes on my desk beside me, and I held up those notes. And it's a copy of the affidavit that I submitted sometime back.
So I'm gonna ask you to turn the affidavit upside down so you cannot see its contents. If
Okay.
Mr. Edwards asks you a question, the answer to which you don't recall, that's fine. Just say, I don't remember. I know it was in about 2015 or whatever you think the answer is. And if he wants to direct you to something to refresh your recollection, he's free to do that.
Okay.
But one reason why we were reluctant to have you or anyone else testify remotely is we can't see what you're looking at, and you need to not be looking at anything other than what's inside your head, okay?
Okay. Fair enough. It's turned over.
All right. And do you recall who you purchased the property from?
We did. We purchased it from the Parkers.
Okay. And who were your next door neighbors on the Habersham Road address?
The Darbys.
Okay. Were they your neighbors for the entire time?
They were.
Okay. So from roughly June of 04 to fall of 18, it was the Darbys?
It was.
Okay. And describe your relationship with the Darbys.
When we saw them, it was cordial. I think they spent as much time away from Atlanta as they did in Atlanta, so we didn't see them that often. We did not have very much interaction with them. We didn't have any, only challenge we ever had was when they cut down some trees along their driveway, which were technically on our property. And then when we asked them about that, they replanted trees to our satisfaction, and that was the most we ever interacted with them.
Okay. Now, obviously, you understand why we're here talking about the easements. Is that right?
Yes, I do.
And easement one, what's your understanding of what that is or was?
I believe that was the easement regarding the parking pad closest to the homes.
Okay. And easement two, what is your understanding of its location?
It's in the lower part of what I'm calling the lower part of the property, closer to West Paces Ferry.
Is that north or south, or do you recall?
That would be south.
Okay. I didn't ask you this. What do you do for a living?
I have been a real estate agent for since about that time we bought the property, since about 2005, and I'm still active.
Still active? Are you still licensed in Georgia?
I'm licensed in Georgia and I'm licensed in North Carolina.
And how much of your work is in Georgia, if any?
Not very much. It's definitely slowing down.
Okay. I want to talk about what you personally saw and observed with respect to easement two, the 14 or so years that you owned it. When y'all bought the property, did you see any evidence of use by the Darbys when y'all bought it?
No,
Were there any paths cut, any grills, any type of structures on easement two?
did you say any paths? P-A-T-H?
Yeah, like let's start with a path, any walking paths that had been cut in there?
I can't remember when we bought the property if there was a path, but the gentleman that helped us with the yard definitely created a path in order to dump grass cuttings and debris from the yard in that area.
From whose yard? From your yard or from the Darby's yard?
My yard. So the only cuttings I ever saw were from us, and the only path I was aware of was one that just was made on a weekly basis by our yard people. Find a place just to dump the yard refuge.
Did you or your family or your workers make any active use of easement two?
Other than using it as a dumping ground, no.
All right. You said as a dumping ground. Explain that for the jury. What do you mean by using easement two as a dumping ground?
Again, it was just yard clippings and sticks and debris from the yard that was put in that area. No personal garbage, just yard debris.
At one point, did y'all have like a walkway that was comprised of railroad cross ties around the garage?
Yes, it was like a little retaining wall. Yes.
Like little retaining steps. You'd have a 6-inch rise and a flat and a 6-inch rise and a flat.
Yes.
Okay. And do you know if those cross ties rotted over time?
They did. They had deteriorated by the time we sold.
And do you know what, if anything, became of those cross ties?
I do not.
You don't know if they were discarded into easement two?
I do not.
Did you ever venture into easement two and just kind of walk around and enjoy the peace and tranquility and beauty and nature and all of that stuff?
I did on occasion. I don't know if it was for the purpose of enjoying nature so much. It's just kind of curious what was going on. We'd lost a couple of trees that one fell over West Andrews and blocked the road. And so there were a couple of moments like that where it made sense to walk in there and kind of see what was going on. And I think my husband did the same thing on occasion, but we did not use that area. It was just a buffer from the neighbors to the south of us.
Okay. And did it appear that the Darbys have made any active use of easement two for any purpose during the 14 or so years you owned it?
I never observed any active use.
The Darbys, you said that they were gone half the year or more. Is that for the entire time, or did it kind of go up and down?
I couldn't put a percentage on it, but they were gone. I believe they had property in Florida, and they were gone a good portion of the time. And then when they were home, we didn't interact socially with them, so we didn't see them when they were home the majority of the time.
Okay. Do you recall the frontage of easement two on West Andrews? Was that something that someone could easily walk through on their morning walks, or was it overgrown?
The width of the easement, is that what you're asking me?
Yeah, the width of the easement on West Andrews, was it clear cut or was it densely forested?
I would call it more dense. It was not clear cut. And so it was we knew it was like an imaginary drive that was in there as far as in our heads. So we knew there was an easement that went in there. We'd been told it was about the width of a small drive, but it was overgrown. And so there were, to my recollection, there was nothing marking the width of that easement. It was just, we just knew it existed.
And did the Darby's ever complain to y'all about the dumping that your yard guy did?
Let's not get into what the Darby said. Right.
Did you ever, let me just ask this. Did you ever have any discussions with the Darby's? And don't tell us what those discussions were, but did you ever have any discussions with the Darby's about the fact that your yard guy was dumping stuff in easement 2?
No.
Okay. Now, at some point, did you ever have any discussions, don't tell me what those discussions were, with the Darby's about possibly buying easement 2?
There might have been a casual reference to that, but there was never a serious discussion about it.
And do you recall when that may have been?
No.
Okay. But subsequent to that, did you ever see the Darby's actually going out and using easement 2 for any purpose?
No.
Did they move back to Georgia after y'all had that discussion and start living there full time?
The pattern when they were in and out of that house didn't ever seem to change to me. I mean, they were there some of the time and gone some of the time. So I don't know to answer. I don't know how to answer that question.
Okay. Thank you, ma'am. I have no further questions. Ms. Stern will have a few.
Stern,
Okay. And I need to be up in front of that one.
you do.
I'm a little bit shorter, Miss Nykerk. Can you see me?
Yes, I can.
Okay, a little bit. Sorry. I'm sorry. Good to see you again. If I heard you correctly, are you saying you're no longer actively practicing real estate in the Atlanta area?
No, I'm a licensed Georgia real estate agent with Ansley Atlanta. So I'm legally I'm an active agent. I just don't, as the years have gone on since we moved away, I do less and less business.
Understood. And did you knew Claire Anderson before you sold the property to the Andersons, is that correct?
I did. We have a mutual friend that we got to know each other through that mutual friend.
When you purchased what is now the Anderson property, was easement 2 wooded?
Yes, it was.
When you sold what is now the Anderson property, was easement 2 wooded?
Yes.
Tell me, did you ever walk the full extent of easement 2?
You mean the depth of it going parallel to Habersham, going back into it? Like behind the former property? No, it was wooded and wild, and I did not attempt to ever walk that portion of the property. I'm sure I walked into it, but I never walked the length of it from West Andrews to behind the Darby's.
Okay, you never walked the length of it.
Correct.
When was the last time you walked in easement 2?
I have no idea. It would have been prior to us selling, and it would have been just putting a foot or two into it. From the path, the only time I went toward easement 2 was on the path on that NOLA property beside the garage that my yard person used to walk in to put the grass clippings and the sticks in. That's the only time I ever attempted to walk into that area.
Okay. And from your property, if someone was walking from the Darby property to West Andrews, you might not be able to see them in easement 2. Is that correct?
Yes.
Okay. So you don't really know whether the Darbys were actually walking from their property to West Andrews through easement 2.
I would say there was no sign of activity on that property. It was wild and remained wild looking. So there was no sign of anybody walking through it as far as trying to clear it and make it, able to navigate it. But no, I did not see anybody walk it, but I wouldn't know if they had or not.
You too.
Okay. You wouldn't know if they did or not. And when you say,
Better answer.
and yeah, for the court reporter, verbalize it.
I did not see anybody walk that property.
Okay.
You just ask two questions in a row. Just ask one at a time.
Yes, Judge. Ms. Nykerk, did you hear I believe you answered it. You did not see anybody walk through the property?
I did not.
Okay. And that's from your view, that's not necessarily all the way back to the depth of easement 2, correct?
Correct.
So someone could have been walking that you wouldn't have seen.
Yes.
Were you aware of the Darby's use of easement 2 as a wooded area?
Objection, assumes facts not in evidence.
I'm just asking if she was aware.
Well, it assumes facts not in evidence, that is a fact, and there's no evidence supporting that fact of which she is supposedly aware.
Every word I heard this witness say is that it was a wooded area, so I'm not sure why we can't ask about a wooded area. Why don't you ask the question again, Ms. Nykerk, you're free to answer it.
Ms. Nykerk, you talked, I believe you called it a natural buffer, easement 2, correct? Between your property and the back property. I don't remember the gentleman's name, but you referred to easement 2 as a natural buffer, correct?
Correct.
Okay. Were you aware of the Darby's use of easement 2 as a natural buffer?
Well, it appeared to me the entire time we lived at that house on that property that they were using it like we were and just leaving it as a natural buffer and not a space that either one of us were using on a day-to-day basis.
So we're using it in its natural
Yes.
form?
Yes.
Okay. Thank you. No further questions.
Do you have any questions for Ms. Nykerk?
No, Your Honor.
All right, do you have any redirects?
Just one or two. Let's talk about this alleged use. Did you ever see the Darbys out there planting stuff in easement 2?
No.
Did you ever see the Darbys out there trimming stuff and clearing it out?
No.
Did you ever see landscapers other than your own landscaper out there?
No.
Nothing further.
Jurors, do you have any questions for Ms. Nykerk? Okay, Ms. Nykerk, thank you for joining us.
You're welcome.
You are free to go. Appreciate it.
Thank you, ma'am.
Pardon me? You can, in fact, ladies and gentlemen, I forgot to ask you because we were, no, I'll repeat it once you're situated. Because we were figuring out what to do with Ms. Nykerk. If you had questions for Mr. David, which you may well have had, and we didn't work through that process. Did any of you write down questions for Mr. David? Because I'll put him back on the stand, so you all can ask. It sounds like he's gonna testify again, but I didn't mean to prevent you all from, asking him any questions. No? Okay, great. Mr. Edwards, next witness.
Plaintiff's call Stacy David for cross-examination.
So look, don't worry, you get situated. We're gonna say it all, we're multitasking here. Once you get situated, Ms. David, you're gonna come on up. You're not, so I appreciate you, being flexible like that. You just let me know when you're ready. That I got to ask. Well, we're at that scene. That's our only. If we were to slide, I think the monitor was in a slightly different place, so that, angled a little towards the other way, slide it there, okay, great. We're good. Okay, we're back on the record in Anderson's versus Davids. I remember after we excused Ms. Nykerk that I had not asked the jury if they had questions for Mr. David when he completed his testimony as a witness called by Mr. Edwards. The jurors indicated they had none. Then I asked Mr. Edwards to call his next witness, and his colleague, Mr. Logan, indicated that the next witness for the Andersons was Ms. David. She is on the stand, and Deputy Gordon is going to swear her in. Ms. David, if you stand back up, please.
Raise your right hand. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and have a seat. Can you state and spell your name for the record?
Stacy, Stacey, David, David.
When you're ready, Mr. Logan.
All right. Ma'am, what have your personal uses of easement area 2 been?
What can they be? Anything legal? Anything we choose for easement two to be legally?
What have your personal uses been?
My personal uses have been not much. I have rarely been out there.
Okay.
But I've used it, my personal would be the enjoyment of my son.
Before you ask any more questions, are you gonna, right now, we don't have the witness on the screen, we just have what might be
yeah,
a
okay.
screen share. And if you're gonna be sharing images, that's great, but if you're not, you should take that down. Great, and you're, excellent, thank you.
Have you ever set foot on the easement?
Yes.
Easement 2?
Yes.
Okay. When?
I couldn't tell you exactly when.
Was it before or after you purchased property?
Both.
Okay. Can we pull up 13?
Give me a minute, apparently
Uh-oh.
logged out of the meeting.
Well, so we're not having any dead time. Now, you took photos of trash that you found in your dumpster.
I did.
Did you take those personally or did somebody else take them?
I did.
Why'd you take those?
I'm sorry, future.
Easy question?
Why did you take those?
This is liberation.
Yeah.
It's me, I'm deliberating. I'm trying to shut that off. Give me a second. Let me share my screen and that there. Good Lord.
Try saying something to Logan, see if we still got the video.
Testing. Yeah.
Disconnect audio there.
Okay,
Are we good now?
Yes.
Hello? Yes, we are good now.
What do you want?
Well, questions on the table. Why'd you take
ask
those?
the question again?
Yeah.
We took the pause.
Why'd you take those pictures?
I took the pictures because when we had left the house, there was nothing in the dumpster. When we came back, there was trash in the dumpster. And I took the pictures so we would have a address of who it was that dumped them in, because there was an address on the box.
Did you take the pictures because you found the fact that there was some trash in the dumpster to be unusual?
Did I found it to be what?
Unusual.
I took the pictures because when there was nothing in the trash, and then when we came back, there was trash and there was no construction work going on. So we knew the trash was not from construction workers.
Right. So you expected the trash bin to be empty
Yes,
and there was something in it.
there was.
You didn't expect that.
No, I didn't expect there to be trash.
Is that why you took the pictures?
I took a picture so we had an address of who put it in there.
Now, circling back to your uses of easement area 2, can you please bring up P13?
The video.
I think so. Should be.
Yes.
Yep. Now, can you see the video?
Hold on, Your Honor, should I stay muted or unmute?
Stay muted, please.
Can you play the video? No, I want you to raise your hand, say stop, make some kind of indication when it shows where you accessed easement 2 from West Andrews.
I'm not gonna be able to tell you where I accessed it from West Andrews unless you had a picture of it like this, not doing like this, because it all looks the same to me. So my answer is gonna be, I don't know.
Was it more along the south end of the easement or the north end of the easement closer to Habersham? Could you tell me that?
I've walked on the easement from West Andrews up to the easement. I've walked on the easement from my property onto the easement.
How do you
We've
access?
seen, I'm gonna interrupt you for a second, just so we can clear this up. We've seen some pictures where there was a path made. Did you walk on the easement before that path was made?
Yes,
Okay, then we should keep going.
Okay, you said you accessed it from your home. How'd you get there?
from my yard, walk straight back.
Through the grass or down the little brick path that we've seen?
I can walk straight through the back of my yard, through our wooded area onto the easement at any point. I don't have to walk that brick area. That brick area stops. It doesn't continue onto the easement. So when I've walked to the easement from my house, I've walked through pine straw, through grass, through a wooded area.
Is there a path in the wooded area?
Not so to say it's a path that someone built, no.
When you say a path, okay, you said a path that somebody built. Are we talking like pavers and
There is not a
bricks or-
pavers, there is not a path. I could walk in any direction and get to the end of my yard onto the easement from any direction I wanted. I could go left and straight and here in the middle and straight and cut over. I could walk a little bit more over here if I wanted and go back and turn left. I can access the easement from anywhere going straight back from my yard.
After you make a turn?
Correct.
Can you bring up 22? Okay, can you, not that one, scroll. Yeah, no, go back, yeah, that one. Okay, ma'am, you said that, as you can see, this is a Google Maps street view from November of 2019. And when did you buy your property?
I can't see a date on this, on the screen.
Can you call it out again, please? You see that this is a Google Maps street view captured November 2019?
I do not see a date. Yes, I see that.
And when did you buy your house?
We bought our house in March of 2020.
Okay. Can you go back to the regular image? Earlier, you said that we would need to show you the whole image and you could point to where you accessed easement to. I don't think the doohickey is working. So can you maybe get down and point to it? The touch screen. Yeah, where she can draw.
Yeah.
That thing.
It doesn't
Yeah.
work with the child pad, so.
Right.
It's essential that you have Ms. Debbie point something out, she will need to come to the big screen.
Or I can hand her the iPad and.
Let's have her go to the big
Yeah.
screen.
Okay.
So I can't tell you exactly where I walked, but I probably walked up through this way. I would have been more on the back of the easement and staying away from visibility from the Andersons. So I probably would have stayed away from his property. I would have gone more along this way.
Okay, and that was back when you first bought the property?
No, we bought the property, we went from our yard. We bought from, I mean, before the property, we accessed it from the back of our yard. With Alden Potts, with the agent.
Okay. Now, you can sit back down if you want.
Olden Potts, is that your name for you?
Alden.
Thank you.
Okay, now, you said that you didn't want the Andersons to be able to see you.
Just that if I've walked the property since February 24th, I would have walked the property in a way that I did not have to view the Andersons.
I thought the easement had already been cleared by February 24th. Did the easement not already been cleared by February 24th?
That's not your question.
Well, ma'am, you just said that you walked in the back of the easement so that the Andersons could not see you after February 24th.
Correct?
My question is, was the easement cleared by February 24th?
If I was to walk from West Andrews up to the easement, they have not cleared the part that Atlanta City has the rights to. They have not cleared that part. There is still ivy, the frontage. They have not cleared that.
Don't talk over each other, so you wait till she's finished answering and then
I
you can
understand.
say frontage or whatever it is you want to ask her about.
What about behind that?
It's cleared.
And it's been cleared since February 24th of 2021.
It was cleared February 24th.
Once you get past the frontage, it's wide open, correct?
Correct?
So how are you going to walk through the easement in such a way that the Andersons don't see you after February 24th?
I don't mean that they don't see me. I purposely stayed away from the easement. So stayed away from the front towards their house. So I didn't have to see Mr. Anderson. So it wasn't for Mr. Anderson not to see me. It was for me not to see Mr. Anderson. So if I was to walk the property, I would have walked in the back. So I'm looking and going where I want to go and not having to see Mr. Anderson.
But how wide's the easement?
I don't know how wide the easement is. I mean, it's more than 10 feet.
More than 10, less than 100?
I don't know. Less than 100. I don't know.
Okay. So Mr. Anderson can't see you if you're at the back of the easement, but he can see you if you're at the front of the easement and vice versa. You can see him.
I'm talking about coming from West Andrews.
I understand. I'm saying if you go from West Andrews through the easement to your property. and
Mr.
you're-
Anderson could see me. Yes.
So in the same way, you have to wait till he finishes.
I'm sorry.
His question may pivot in a way you're not expecting, so please let Mr. Logan finish the question. He'll give you, I'll make him give you, if he doesn't, all the time you need to answer the question.
Sorry. Yes, sir.
So I feel like we're talking past each other. So let's kind of turn it back. We have along the street, there is this frontage area, correct? And there are still ivy, trees, shrubs, whatever along that,
Yes.
right? Behind that, between that and the property line that the Andersons share with you, the easement area has been cleared, correct?
Correct.
So my question to you is, if you're at the back of the easement area, you can't see Mr. Anderson? But if you're at the front of the easement area, you can see Mr. Anderson.
If I'm on the edge of West Andrews, walking up, there's shrubbery there. And there's shrubbery in front. If I'm walking here, there's shrubbery in front. So then I don't directly see him right there. Would I see Mr. Anderson if I walked up on the property? If he was there, yes.
So
If I walked up on the easement.
so you haven't walked up on the easement,
I have walked up on the easement.
just to the frontage area.
Can you put
I've
the
walked-
picture up so we don't?
I've walked the entire
Yeah.
easement from left to right, north to south.
Yeah, just pull up one of the ones that, yeah.
So which one?
No. Well, yes, but keep scrolling. That's fine. Just rotate it. Yeah, that's fine. Just rotate it.
All right.
Yeah, there we go.
One last time.
So my question is, do you see the area behind what appears to be a net?
I do.
And then that's covered in pine straw. And then behind that, you have what looks like some more trees and ivy. I'm asking you, would you walk kind of through the easement behind the net?
I have walked behind the net. I've walked in front of the net. The net is not always in the same spot.
So you walked in front of the net. When did you walk in front of the net?
I couldn't tell you the time I've walked in front of the net. I've walked all over the entire easement.
Did you do that before or after February 24th, 2020?
I couldn't tell you. Before, I've walked on the entire easement before February.
I'll just move on. Let's go back to, we had been talking about the trash in the dumpster. Now, you say that you took a picture to have an address.
Yes.
Is that so that you could leave and you'd still have it?
It's so I would have it without climbing in the dumpster.
Understood. And whose address was it?
Tracy Anderson.
And did either you or your husband or anybody go and speak to Mr. Anderson? Not asking for what was said, but do you know if anybody spoke?
My husband spoke.
Okay. And after he spoke to Mr. Anderson, did you ever again see any trash in your dumpster that you believe should not have been there?
I don't know. There was always trash in the dumpster afterwards.
Was there any that you attributed to someone other than your own trash generators because of the work we've done at their house?
No,
And did you take any more pictures?
no.
Is it fair to say then that that particular issue, not asking about everything, but that one issue, Mr. Anderson putting trash in your dumpster, was dead and buried after your husband had a conversation with him?
Yes.
Did you ever take any pictures of a tree being removed from easement 2?
No,
Did you ever take a picture of a shrub being removed from easement 2?
no,
Did you ever take a picture of any ivy or ground cover or vines, trash, or anything being removed from easement 2?
yes.
What was that?
It was a picture of equipment with the shrubbery in front of it, with the ivy and all in front of it. I took a picture of equipment.
Equipment. Can you pull that up?
It's Exhibit A. Has it been offered? Yes. So, sure.
Yeah, because yeah. Do you recognize this?
Yes,
Is that the picture that you took?
yes.
You took that personally,
I'm not sure if that's my picture or Jean Noel's picture.
but you recognize this.
I do.
Okay. When roughly, I'm not asking you for a specific date, but month generally, when was this taken?
April.
Of?
I don't know, April, September, I'm not sure when it was.
Was it after you bought the property?
Yes,
Did you take this picture because of the fence that was going up? Or did you take this picture because of the whatever kind of machine that is?
because of the equipment on the easement.
Do you know what kind of machine that is?
I do not.
Did you, after and before you took this picture, watch and see what the machine was doing?
The machine was not moving at the time when I took the picture.
Did you ask anyone what the machine was there for?
I did not. I would have reached out to Casey. I reached out to Casey and told her it was there. I didn't ask why it was there.
When did you do that?
I'm not sure when the date was that I would have sent out this picture.
Was this before you were served with a complaint? Or after?
When was I served a complaint?
There's not a fence up in this, correct?
There is not a fence.
And when was the fence put in?
October 6th.
So this would have had to have been taken before October 6th.
Yes,
And we're talking 2021, right?
yes.
Okay. Was it 2020 or 2021?
Don't know.
When did the fence go in? October 6th of 2020 or 2021?
I bought the house in March. The fence went up October of 2020. So this is 2020.
So you would have notified Ms. Sturm in October of 2020?
I don't know. I don't know when I notified her. I don't know when I took the picture. I don't know if something would have been moving on the easement. I would have notified our attorney had we had attorneys at that time.
Would you have documented it?
No.
Why not?
Why would I document it?
You documented the trash. Why would you not document something happening on the easement?
Well, if you take a picture, isn't that documentation?
That is, yes, I agree. But I'm asking you, if you notice something going on the easement, you just said that you would document. You document these things. Yes?
Taking a picture?
That counts? Yes.
Okay.
Do you have any other pictures of any equipment, any landscapers, anybody doing anything on easement area 2 other than this?
On easement 2, I have a picture of the sod.
Did you take a picture of someone installing the sod?
I took a picture of the wheelbarrow and the sod on the side of the street and the wheelbarrow on the easement.
Did you produce those?
I gave all of our pictures to Casey.
When did you take the picture of the wheelbarrow and the sod?
On the day that they were installing the sod.
Did you take that picture from inside of your car or outside of your car?
From inside my car.
Did you ever speak to either Tracy or Claire Anderson about any trees, vegetation, shrubs, anything being taken out of easement 2?
No,
You did not. Why not?
I didn't speak to either one of them.
Man, I guess my question is, if you observed easement 2 being disturbed,
Yes,
Why would you not go and speak to Mr. or Mr. Anderson?
I
No,
spoke
Mr. or
to-
Mrs. Anderson.
Because I spoke to my husband and my husband would have taken care of that.
So any discussions with the Andersons regarding easement 2 would have gone through your husband?
I don't know if any discussions would have gone through my husband. All discussions about easement 2 went through my husband, yes.
Are you aware of where your contractors would access your property from West Andrews?
In my driveway are the ones I'm aware of. Anywhere else, no.
So you are not aware of any contractors parking on West Andrews and accessing your property from West Andrews across the Andersons' property?
I am aware because I was told that Mr. Anderson complained about it.
After you found out about that, did you take any steps to direct these contractors not to access your property over the Andersons' property?
Yes, I told our contractor
And what did you tell him to do?
that if they were to park on West Andrews, they needed to walk behind on the easement and not through the Andersons' yard.
Did you ever observe them walking through the easement?
I did not.
Let's go back to this issue with the sod. You said that you took a picture of it. Did you speak to anybody?
I did.
Who'd you speak to?
I spoke to two gentlemen that were laying sod.
What'd you tell them?
I said that they needed to speak to the property owner, that the yard was in litigation and that they were not on his sole property, that this was an easement that was shared.
The property was in litigation on February 24th, 2021.
There were talks. I don't know. Hold on.
Excuse
I
me.
told them that this was an easement. This was an easement and that it was not his sole property and that he needed to speak to the owner.
So you didn't tell him that it was in litigation?
I did not tell him it was in litigation, no.
Did you threaten to call the police on him?
I did not.
Why not?
Because it was a friendly conversation. I didn't need to threaten to call the police to them.
If it's friendly conversation and everything is all hunky-dory, why would you not then just simply go and knock on the Andersons' front door like your husband did with the trash and speak to them about this?
I didn't speak to the Andersons.
I
I
understand.
did not
you
have a
didn't-
relationship with them. And after the trash incident, I did not speak to them. I did not have a reason to go over and speak to them.
Is the trash incident the reason that you didn't have any reason to go speak to them?
Probably.
So you were so upset with them over a box in a dumpster that you refused to go speak to them?
I wasn't so upset. It was rude. It was disrespectful. The neighbors had not come over to say, hi, hello, my name is, but yet they just threw their trash into our dumpster.
You have just testified that after your husband went and spoke to Mr. Anderson, no more trash ended up in the dumpster, correct?
Correct?
Obviously, communication solved an issue. why would communication have not solved this new issue?
I didn't say it didn't solve the issue, but it's still never, I never still wanted to go over and speak to the Andersons. I had no reason to walk over and speak to the Andersons.
Instead, you speak to their landscapers?
I spoke to the person laying sod on the easement. Yes, directly to the person doing it, and told him to speak to the person that hired him to do it. I also asked for his business card, which he gave me his manager's business card.
Now, have you previously testified that these landscapers didn't speak very good English?
They did not.
So the communication with them was kind of spotty?
Yes, it was kind of spotty.
So, I mean, at that point, were you even aware that they understood what you were talking about?
No, they probably did not. So he gave me his business card. He said, here's my boss's business card. He handed it to me. And I then called his boss.
So you have what sounds like a somewhat unproductive conversation with some folks that don't really speak English. And you didn't think to at that point to go ahead and kind of address the issue, go and knock on the Andersons' door?
Yes, sir.
I object to the questions, mischaracterization of the testimony, and it's also cumulative. He's asked this now 3 times.
So I'm gonna sustain it on the second part. I don't know if it's mischaracterization, but, I think the jurors get it. She didn't talk to the Andersons.
I'll move on.
Okay.
Prior to February of 2021, had you ever spoken to either of the Andersons?
No,
And since February of 2021, have you spoken to either of the Andersons?
Mr. Anderson,
On how many occasions?
once.
What was that conversation about?
On February 24th,
Yes, ma'am.
my only words to Mr. Anderson were, you are a real gentleman, aren't you?
And that's the only conversation that you've ever had with Tracy Anderson.
That's the only words that came out of my mouth to Mr. Anderson.
That is not what I asked you, ma'am. I asked you, is that?
That's the only
Don't
conversation.
answer the question.
That's the only conversation that you've ever had with Tracy Anderson.
Yes.
That's the only time that you've ever interacted with Mr. Anderson.
No, you asked, was that the only conversation? You asked it a few times and she's answered it now. We're not doing triplicate or quadruplicate of, did you go to their door after you talked to the sod layer? Did you have more than one conversation with them? So
Come on, I'll move on.
let's move on.
What did Mr. Anderson say to you in February of 2021?
February 2021, February 24th, Mr. Anderson, without using words, spoke to me with his middle finger. And he said to me, roll down your window. So I rolled down my window. And he said, you motherfucking fat bitch. If you ever come on my property again, I will run you over. I will sue you. And then he proceeded to say, after I said, you are some gentleman, I am a gentleman. And then he said, you are going to die. That was our conversation. He also said, I play golf with someone who knows you and he hates you and he's not your friend and his wife hates you. And this person calls you a fat bitch. Everyone, you think you're so great that your kids go to Lovett. Everyone at Lovett hates you. Those were the words from Mr. Anderson. Those were his first words and only words to me.
Fair enough. And after that incident, you sought a restraining order against Mr. Anderson, correct?
Correct.
Now, was that asking for a restraining order because Mr. Anderson was stalking you?
It was asking for a restraining order because I was terrified of the man.
You recognize that man?
I have seen this.
Can you please read what it says there at the top?
So let's make sure that our lawyers know what you're showing her as well. If it's an exhibit, just give them the number. If it's not, give them a copy.
Just mine.
And one of the exhibit folks who can say, he 39, or is it?
Yeah. Does it say stalking ex parte temporary protective order?
It does?
And did we have, was there a hearing on this restraining order?
There was?
And during that hearing, did you acknowledge that you weren't even sure if Mr. Anderson had been stalking you?
I don't recall that. I don't recall having that conversation, whether he was or was not. Did I think he was? Yes,
You believed he was stalking you?
I did.
And you've interacted with him one time?
Correct.
Was the restraining order, was that your decision?
It was? It was a joint decision between myself and my husband.
Do you think Mr. Anderson's still dangerous?
Yes.
You're still afraid of him?
Yes.
Initially, you stated that your use of the easement is your children's enjoyment?
That's part of it. My son, yes.
Okay.
How many kids do you have?
I have two kids.
Okay, boy and girl, boy.
I have a daughter who's older and a son.
Now, so presumably they use the easement, yes?
Yes,
In full view of Mr. Anderson's home, yes?
I've not been in Mr. Anderson's home, so I don't know if he can see them or not.
In full view of Mr. Anderson's property?
They can see part of his house, yes, the side of his house.
Can they see his driveway?
They can see his driveway.
Can they see his garage?
They can see the outside of his garage.
Can they see when he pulls up into the driveway in his car?
They can if they're looking, yes.
Are you sitting in your car when they're out there on the easement?
I have before. I've sat in the car on Andrews.
Have you ever walked out to the easement and kind of sat in the chair?
The chair's no longer there. The chair was removed the day it was put down.
Have Have you ever gone out onto the easement with your children while they're playing?
Yes,
Do you always go out onto the easement with your children while they're
No.
playing? No. Do you have any personal knowledge of Mr. Anderson waving firearms around?
fire,
That's a fine question, but I don't want there to be confusion. Can you explain to the witness what you mean by personal knowledge?
When I say
You told
personal-
You saw it, you read it in the newspaper.
When I say personal knowledge, I mean, have you seen him? Have you heard about him? Have you seen a picture? Anything like that?
I heard from the person that saw the
So
gun.
someone told you.
Yes,
Do you have any other reason to believe that Mr. Anderson owns any guns?
no, I have no reason to know anything about Mr. Anderson with guns
Do you believe that Mr. Anderson owns guns?
because he said he did. Yes,
Okay.
I believe that.
Now, you said that you were notified. I don't want to hear about any conversations, any content of those conversations, but you say that you were notified that Mr. Anderson had a firearm. Did you call the police?
I did not.
Why not?
I went straight to the situation. I didn't call the police.
When you say you went straight to the situation, what do you mean?
Your Honor, I'm gonna just forewarn her not to recite any communications she may have had with my firm.
Okay. Want to clarify a little bit of that forewarning. You, of course, can testify to anything you want. If you start talking about lawyer-client communications, that opens a door that your lawyer may counsel you not to do. And we may have to pause so you two can talk. It's not a problem for you to say, I reached out to my lawyer, but we stop there. It's not, and I told him X or her, and she told me Y. And that's not what Mr. Logan's trying to get out. He's trying to understand what you did if you didn't call the police. So
Yes, sir.
it's okay to say, I reached out to my lawyer, but then Mr. Logan ought not to say, what'd you say? What'd your lawyer say? If he does, I'll interview.
Okay, thank you.
So, without revealing any kind of the content of communications that you may have had that are privileged, when you say you said address the situation or went to the situation?
I went to the
Went to
situation.
the situation. What does that mean?
That means my son called me and said,
I don't want to hear what your son said, ma'am. That's hearsay.
Okay.
I just
well,
want-
I went to the situation.
Yeah, she's entitled to answer. He's opened the door to ask what she did.
Okay, and she can explain it, but he's free to object to hearsay. So it's not opening the door where he said, what did you do next? And she says, I talked to your lawyer who called me. So don't talk about what your son said, but you can certainly talk about, you got a call from him and what he said to you made you hurry on out to the easement.
Yes. He called me and I was with my husband and we both got to the easement. Went to the easement. We were not home and we went to the easement.
Where were you?
I don't even remember where we were. We were somewhere we were able to be close enough to get there quickly.
I mean, are we talking like next door? Or are we talking you were having lunch 20 minutes away?
We were not 20 minutes away. We were somewhere in the neighborhood. I'm not sure where I don't remember where we were, but we got there.
So you were under the belief that a man that you believe is dangerous was waving a gun around and your first instinct was not to call the police.
First of all, no one said waving a gun around. I never heard anything about waving a gun. And you don't want to hear what he said, so I'm not going to tell you what he said.
You gotta make sure you're not creating what was said and saying you can't say what was said. If you want her to tell you what her son said, feel free to ask, but otherwise you can't substitute what you think he may have said.
Yeah, I don't want to know what your son said. You You were under the impression that Mr. Anderson had a gun, yes?
When he called me, I was.
You believe Mr. Anderson is dangerous, yes?
I do.
Why would your first response at that point not be to notify law enforcement?
It just was not. My instinct was to rush to my son. I did nothing but rush to my son.
Did you
And I
have your phone with you?
notified my attorney.
Did you have your phone with you?
I'm sure I had my phone. Yes, I had my phone. He called me.
Were you in the car or were you walking?
We were in the car.
After this incident, after the incident with Mr. Anderson in February of 2021, whenever, really, have you had security cameras installed around your house?
We have Ring cameras. Ring.
That's like the doorbell, right?
It's a Ring camera.
Does it have, is it just the doorbell or is it a whole system?
No, one of them is a doorbell and others are just cameras, but they are the brand Ring.
Okay, I understand. Where are they positioned around your house?
We have one at the front door.
Okay.
We have one in the driveway parking pad. And we have one onto our back patio.
Where are they pointed?
The parking pad is the one in the driveway. The front yard, front entrance of our front door and our patio.
Okay. Do you know about when those were installed?
After February 24th.
Do they capture audio?
They do capture audio.
Whose idea was it for your son to go and practice lacrosse on Eastman Area 2?
It was his idea.
Where had he been practicing lacrosse prior to that?
Prior to living there,
Prior to living there, prior to, at any point, I mean, just all before. His entire history of practicing lacrosse prior to the first time on Eastman Area 2.
so you want me to go back to the years that he started playing lacrosse and where did he practice? He practiced at schools. He practiced at the lacrosse fields. He practiced in our yard.
Which part of your yard?
Which house are you referring to?
I don't know about any other houses, so the one on
Just
Haversham.
asked me for
Well, he's
every
narrowed it-
incident.
Narrowed it down, because he should, and he's asking about the house at issue here.
The house at Cottage, at
At-
where
on
we lived
Haversham.
at Habersham.
Yes, ma'am.
Before the easement, before he moved and put the nets up on the easement, he would have practiced. I think he had a bounce back. I think he had a bounce back in the front yard.
Is there grass in your front yard?
There is.
Is there grass at the school fields that he practiced on?
Some fields have grass and some have turf and some have pine straw.
Which ones have pine straw?
Some of the sides of Lovett's back fields.
The sides?
Denny, one of the fields at Lovett.
When you say the sides, I mean, are you talking like a side field or the periphery of a field?
Do you know lacrosse?
No, ma'am.
Okay, well, if you're practicing lacrosse, you also can practice on the side of a building, which you are throwing the ball back and forth. You throw the ball, you catch the ball. Back, it's called bounce back, and that's wall ball. So he does that on the side of walls. He's practiced lacrosse many places.
Okay. Have you ever spoken to either Diane or Lynn Darby?
Yes.
What did you say to him
Which time?
first time you met him?
Hi, nice to meet you. They owned the home I bought.
Is that the extent of the conversation?
I have no idea. I don't remember our extent of our conversation when I first met the Darbys.
Okay, let's narrow it down. Have you ever spoken to either Diane or Lynn Darby about Tracy or Claire Anderson?
I have not.
Yes, sir. It's down. It's passed, okay. So we have more time. How long do you think, the remainder of your cross-examination will go? You can say 6 hours. I'm not saying we're gonna finish today, but I'm wondering if we might finish it today. Because if not, we may just break. We need to pause for a minute anyway. But if you've got 20 more minutes, we'll take a quick break, let everyone stretch, and then we'll try to wrap up this cross today.
It could be 20 minutes. It kind of depends, unfortunately.
Okay, well, let me ask the jurors. So we need to take about a 10-minute break now. We also, sorry, we also could just stop for the day and then we'd start tomorrow at 9, normal start time, not a 1:30 thing. Are folks okay waiting 10 minutes and picking up, or are there folks saying, I'm seeing a lot of nodding heads. Let's take a 10-minute break. If after the 10-minute break, some of you say, no, Mas, you have had a free 10-minute break here and we'll in for the day. But head on in there, please. We'll get you back out here as soon as we can.
All right, good.
All right, Mr. Logan, anything on the record before we break?
No, you're not.
Mr. Schneider? No. All right, let's take a break. Mr. Williams, I will just, let us know when you're done. Do what you need to do, please.
It's a quick one.
No, it is what you need. And I'm sorry, you should have flagged it earlier, I didn't mean to run you past that. All right, Mr. Williams, are you ready?
Oh, yes, sir.
We are back on the record. Deputy Gordon tells me that the jurors are ready and they want a hard stop at 5:45, which is about 15 minutes. So you'll cover what you cover in 15. You don't need to finish, but you'll cover what you cover. We'll also let you know that the jurors have reminded Deputy Gordon that several of them were the ones where we said, don't worry, Friday, you go to your funeral, you go to your et cetera. So we're not trying this again. If we need to figure out a day next week that I don't have, that we bring the jurors back, we can do that. But I'm also reading the jury's body language, and I get the sense they have their fill of two fancy households fussing over an easement, and they're ready to let you know what they think. I don't know that anyone will be happy with what they think. You asked for a jury, you've got a jury. That said, I also appreciate that you have messy cases that you need to step forward, and folks have been hard at work. We haven't wasted time here. So just know that you may need to agree if you want to press on Friday rather than we find a date where all of us, including the 13, can come back with less than 13, maybe less than 12. I will poll them in the morning when they come back. I'm not gonna make them stay late, but they were reminding Deputy Gordon of some obligations that we said we could handle. And it could be that we carve out some time on Friday that doesn't start at 9 so people can do funeral or other things. We'll see. So I want to lay that out there. It's not an instruction, it's an observation and maybe an exhortation. Mr. Edwards, you look like you want to say something.
Yeah, in the interest of moving this along, we can stop right now. I don't know if they're going to ask any direct at this point. I don't know if Nedwick is going to have any questions one way or the other, but we can finish with her. We've got one more witness, and that is yours truly. My direct should take 5 minutes, if that. The cross should take 2 or 3 minutes or 2 or 3 hours, depending on how they want to go. So, I mean, that's where we are. We could conceivably finish today.
I mean, you could rest
Yes.
if there isn't going to be a direct or whatever we call Ms. Medlick's questions
If
for.
there's no direct, I'm not doing anything.
Okay. Mr. Schneider, I am not in any way precluding your full exploration of this witness at this point. If what we hear from Mr. Logan when the jury comes back in is actually we don't have any more questions, would you want to ask questions now? If so, would it be brief? Or would you just reserve your questions to the David's case in chief?
Your Honor, I would reserve it just for the sake of expediency on the case in chief.
Okay.
What I would ask wouldn't be satisfactory for us to do that now. So
Okay. So why don't we have the game plan then? We bring the jury in. You're going to say, I'll just say, pick up where you left off. You'll say whatever you want to say in connection with actually I'm done. I'll get answers from Mr. Schneider, Ms. Medwick, and then do you envision counting on Mr. Edwards on his attorney's fees, or is that not going to be a big cross-examination?
we have a couple of technical issues with it.
Okay. All right, well, we'll start the cross, and if we don't finish it, that'll be a short in tomorrow morning, and I'll let jurors know before they leave today. All that's left is a little follow-up. But when you say technical issues, Mr. Edwards presented that it could be 2 minutes, it could be 2 hours. I'm assuming it's not 2 hours, as technical as it may be.
Right now, I more of a legal technical issue, not
Is that something that we'll work through, or
Yeah.
you need to
Yeah.
lay some groundwork for questions for him?
I think it's something we could work through.
Okay. All right, let's bring the jurors in, please.
All right, juror.
Going to the chief seats. Chief seats, yeah, I'm going to the chief seat this time. Way up in the back.
Jurors are present and accounted for.
All right, thank you for returning, jurors. Mr. Logan, you were gonna get to your cross-examination, I will W. Are you left up?
I have nothing else at this time, Your Honor.
All right, thank you, sir. Mr. Schneider, do you have any questions for Ms. David at this time?
We do not, Your Honor.
All right, and no, any questions?
Not at this time, Your Honor.
All right, Ms. David, you may step down. Thank you.
Thank you.
Oh, right, don't step down. There may be questions from the jurors. Do you have questions? And if you do, get them to Deputy Board. I don't mean to shortchange that. You just suddenly had some, yes, no question. And these jurors are slowing everything down.
Any more questions?
No, sir.
Thank you, sir. Okay. Ms. David, can you share with the jury a little more context about your lone interaction with Mr. Anderson? And by that, I mean, you were in a car, he was not in a car. How did the conversation start?
The morning of, I had taken my children to school, and that's when I stopped and talked to the yardman because that was on my direct path to school. Took my children to school, came home, went inside to get ready, came out, got in my car, and as I'm backing out of my parking pad, I realize as I'm backing out, Mr. Anderson is standing right behind the wall of my parking pad. So that is how it came about. And he's standing there with his middle finger and he's doing this, roll down your window.
And then the rest that you shared with the, that's how that unfolded. Middle finger, roll down your window, you roll down your window, then the exchange that we heard.
Yes, exchange happened.
Okay. Mr. Logan, based on that question, do you have any follow-up?
Just a couple.
Okay.
And ma'am, during this encounter, you were pleasant the entire time?
Excuse me?
You were pleasant the entire time with Mr. Anderson?
I said one thing to Mr. Anderson. I
You-
sat in silence and said one thing to Mr. Anderson.
You didn't tell him he was a horrible man?
I did not tell him. I don't know Mr. Anderson. I didn't tell him he was a horrible man.
You didn't tell him that he had multiple wives?
I don't know how many wives he's had. I don't know anything about him at this point.
All right, nothing else.
Thank you, Ms. David. Appreciate it. Mr. Edwards, next witness.
Plaintiff calls Randy Edwards.
All right. You're gonna roll, Mr. Logan.
Raise your right hand. Do you swear affirm that testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Have a seat. State your name for the record.
Randy Edwards, Randy Edwards.
Mr. Edwards, do you represent Tracy and Claire Anderson in this matter?
Yes, I do.
And have you reached a fee agreement with the Andersons in this matter?
Well, yes, we started with a fee agreement, and then over the course of time, we've modified the fee agreement. Originally, it was a straight hourly rate. Over the course of the case, we revised it to a reduced hourly rate with a success fee based upon what happened at the appellate level.
Can you explain what a success fee is?
Well, sort of like betting on yourself. We do a lot of contingency work, either full or partial contingency. And the success fee is, I want my clients to know that I've got skin in the game. I'm confident in my legal position, confident in my ability as a lawyer. Tell them, if we do X, I'll take a reduced hourly rate instead of charging you full boat where I've got no risk. I want to have risk with you. And I will tell them, in this case, we reduced my hourly rate from $425 to $250. And on the back end, assuming we had a successful result at the appellate level, my hourly rate would double, go up to 500 an hour. So that's what I mean by a success fee. We do that. We do a lot of, I do mainly straight contingency, but we do a lot of reduced hourly rate with partial contingencies. And Tracy and I agreed that was a fair structure here.
And have you tracked the hours worked on the case?
We do that on a regular basis. We have accounting software that we have actually changed during the course of this case. We used to use what was called tabs 3. You enter your time and it does it automatically. And now we've switched over to a My Case software. But yes, we keep track of our time, although giving my proclivity for contingency, I'm not real good at entering my time on a day in, day out basis.
And have you prepared a set of invoices reflecting the amount billed to Mr. Anderson?
Well, I can't say I prepared them. Those are created in the ordinary course of business. And yes, those are in the regular course of business.
All right.
Now, we have redacted them because we don't want to reflect what we're doing. Don't want to say talking to Tracy about X. So that stuff is redacted.
Redacted meaning not that you didn't account for those hours, but there may be entries in there that say contact with client, and then what follows is marked out because that's not anyone's business but yours and your client's.
Correct.
Okay.
Now, as we get closer to the trial, just general trial prep is the description, and everybody knows that. General trial preparation is the description. That doesn't give away anything, so that's not redacted.
I'm showing you what has been marked as plaintiff's 61. Can you recognize that document?
Yes, sir.
What is that?
This is a compilation of our exhibits, not our exhibits, our bills. I believe we've got a total of 6 bills. Again, being primarily a contingency lawyer, I don't send out hourly statements every month. Just when it gets up to a certain rate or a certain threshold, I'll send a bill out.
All right. And this is, this document is prepared in the normal course of business?
With the exception of the redaction, yes.
Move to admit plaintiff 61.
The objection of plaintiff 61.
Yes, Your Honor, I object to plaintiff 61. It's not competent evidence of attorney's fees either reasonable or necessarily incurred in this case. A lawyer cannot submit in support of a claim for attorney's fees fully redacted statements as are presented throughout plaintiff's exhibit 61, with the exception of perhaps, I think, his trial prep time. So I would object to plaintiff 61 as being in violation of the burden, unable to establish the burden of proof and irrelevant.
Okay, I'm gonna allow 61 in, but before the end of trial, either I'll need to see an unredacted version, and it may be that ultimately you need to see some of the unredacted version, because I share your concern that almost every entry is redacted, and that makes it hard to assess what exactly is going on. So I know there needs to be a balance struck. So I'll admit 61 and let you proceed with the examination to establish that baseline amount, but it will be subject to the concerns raised by Mr. Snyder. I don't know that we'll need to resolve in the presence of the jury.
And what is the,
My concern is that he's going to testify as to the sum of these fees, that may be influenced by the outcome of our discussion about the redaction.
It may, and so the number may be lower that the jury ought to consider by the time they're deliberating about what attorney's fees will be. But I don't think we'll work through it at this juncture, but you are preserving that right to say the number was X. Now that we've seen what the redacted entries are that don't say prepare for trial, which is virtually everything else.
Right.
You know what the number is now, X minus Y.
I'm just preserving my objection. Right?
And it is preserved.
Thank you.
and what is the total amount billed to Mr. and Mrs. Anderson?
Well, I can expand upon what we did on the reasonableness if you'd like, but the total amount billed through Sunday, or not billed, incurred through Sunday is $92,962.23, which includes an $18,475 success fee. I've also calculated additional time through the close of business yesterday for the trial, 36 hours for each of us at my rate of 500 and your rate of 400, 18,000 for me, 14,400 for you, total of 32,400. Add another 8 hours for today, whatever that math comes up to. Total, subject to today and tomorrow, is $125,362.33.
Okay, and can you explain the work done?
Yeah, if we look at the first invoice, this reflects our time from March 26, 2021 through April 15, 2021. What we were doing during this time was, number one, preparing to defend the stalking temporary protective order that was issued, a number of discussions with opposing counsel, and then drafting and filing of the complaint, which we also have expenses on here. We show the filing fee. That's the expenses or advances are not redacted. Filing fee, filing this case on April 12th, 2021. Some filing other documents. So the first invoice is for the initial defense of the TPO and the drafting and filing of this lawsuit and some communications with opposing counsel. The next invoice begins 6/18 of 21 and goes through August 18 of 21. Again, that's primarily going to be the discussions that were alluded to earlier between myself and opposing counsel, and also in the early mid to late August, there is some time for a motion that we filed, an emergency motion that we filed in the court. We continue on. The third invoice reflects time from September 22nd of 2021 through December 2nd of 2021. One of the things in this case, seeing as how it involves what we call a quiet title action, it's automatically referred to a special master because surprisingly Superior Court judges have better things to do, more important things to do than to deal with title issues. So that's referred to a special master. So we had to have a hearing before the special master on some issues related to the validity of the title and some other issues. So there wasn't a whole lot of time in this. The time for that was only 4,675. And let's see, we have a U.S. legal support. That was a transcript that was taken down. The next invoice is from January of 22 through February of 22. There was a lot of activity going on at this time. That's when we took the David's depositions. That's when they took the Anderson's depositions. We also took Mr. Shostak's deposition during this time. So there's a lot of time preparing for and taking and defending depositions in a relatively short period of time. This is January 20th through February 2nd of 22. That's a total of 14,462 in time. Then we move forward. Not a lot of activity in this case. The next entry, and this is kind of out of sequence, the next entry is invoice number 141, invoice date March 9th. This is unredacted. There's really only one redaction, and that is on March 4th, 2024, correspondence from Eric Logan for 1 hour. I know what that was regarding. We can talk about that if we need. And then the very final invoice, which is actually out of sequence, is invoice number 142, and this covers time from September of 22 through August, September of 22 through July of 23. And this is This is the appellate portion of the case. This is when we're drafting briefs at the higher court level. So in my experience, I've been practicing law going on 32 years. The time for the work we did is very reasonable. I imagine it's fairly light compared to what the Weissman folks have billed. And the rates, the original rate of $425 for me and $250 for you was reasonable. I believe the success fee, the reduced hourly rate was more than reasonable, and the success fee is also more than reasonable.
No further
Do you have
questions.
any questions?
No.
All right, Mr. Schneider, do you have questions now? Do you want to wait till tomorrow morning, or is your main focus what we work through outside the presence of the jury in connection with the sparse nature of the written bills as supplemented by what we've heard from Mr. Edwards?
I would prefer not to take up the jury's time on that. And I
Okay.
believe we could probably just work through it if I can be provided with an alternative version of this.
Okay, we'll talk about that outside of jury's presence.
Thank you.
Mr. Logan, next witness,
I think
We rest.
plaintiff rests. All right, ladies and gentlemen, a couple things. We've reached a juncture where it's a natural break time. Deputy Gordon told me he wanted this to be the break time anyway. I may be about 2 minutes past that. I apologize. I want to talk with the lawyers about what's left. You've been telling Deputy Gordon, been reminding Deputy Gordon that some of you had conflicts, funeral, et cetera, things that were happening on Friday. I'm going to ask you to compile those so that what we start with tomorrow morning is actually input from you all about what's going on your Friday. Not anything new, but something you told me about before, because I have my notes, I'll pull them out, but we need to make sure that we are respectful of the commitments we told you we would honor. So we'll talk about that first thing in the morning. I'll get from these lawyers what they think is left. We've got all day tomorrow. No one had a conflict on Thursday. And I don't have drug court, so I'd ask you all to be very close to 9 a.m., remembering that we can't start if one of you is late. Things do happen. A judge who's helping me with another case comes in on I-20 and was 40 minutes late because I-20 was shut down if you were heading eastbound. And everyone had to wait because it was a judge. So, and you guys are like judges, because if any one of you is not here, we can't get going. If one of these lawyers is missing, there are a bunch of these lawyers. We'll go ahead without the one who's missing, but not any of you. So please call if you get stuck somewhere. And we'll aim to start as close to 9 as we can. Usual exhortations, no outside research. Don't talk about the case with folks. I'm sure you don't want to talk about it right now. Don't, do something different. Any logistical questions? Sir.
When you said call, is there a specific number or person that we call for this case? Or do we just call the jury number? Where do we call?
That's good question, because if you call the jury number, they're like, you're not our responsibility. I don't know where you went. If we were in my courtroom, I would have put that up on the board, but I'm going to tell you now the number. If you'll write it down, type it in your phone, whatever you want to do, use one of those free note cards. It's 404 612 6907. That's Deputy Gordon's personal cell phone number. No, not really. I'll give that out. That's my chamber's number. And so hopefully someone will answer if you're calling at 7 in the morning, because you just know traffic's going to be bad, you'll get voicemail. But that's my office. And so someone will answer it and say, look, I'm one of these jurors on the Andersons and David's case. Probably want to know your name just so we'll be able to track you, but say, here's what the issue is.
Can you repeat it?
Yes, 404 612. It's okay, 6907. I want to make sure I said it right the first time. 6907, that's the direct line to chambers of 8D, 8 Delta. That's my office and courtroom. And someone will take your call and you'll let them know what the deal is. And if it's, look, I'm only gonna be 15 minutes late, we'll all calm down. But we have your numbers too. Some of you may have received calls like, hey, where are you? And your answer is, I'm on the escalator, I'm coming. But we'll nudge you if it's 9 and we haven't seen you, but nudge us if you're stuck somewhere, okay? Any great question, any other logistical questions? All right, seeing none. Thank you for being flexible today and staying a little bit late. Enjoy the rest of your evening.
All rounds for the jurors.
All right, you all can be seated. So what we have left is the entire David defense / presentation of their counterclaims. And any defense to that, and then any rebuttal, and we have to have a charge conference. I will tonight try to work through some of these charges, so I can get you a draft. Then of course closings and charge of the jury, and then they need to deliberate. And I don't know how much time we have with all 13. So be thinking tonight about how you want to move forward. We may hear from the jurors tomorrow that if we're spilling into Friday, we've got less than 13. We lose one. But if we're going less than 12, everyone needs to agree to that, or we come up with a plan B. So, Mr. Edwards, anything you want me to be thinking about in terms of these trial logistics tonight?
No, sir, I think you got it covered.
Okay, do you envision, I know you don't know what's gonna come from defense counsel, but do you envision any rebuttal case?
Possibly, but if it would be, it would be extremely short. I've never seen a rebuttal take more than an hour.
Okay. And Ms. Medwick, I guess the answer to the question of what might you put up, it wouldn't just be, I guess, examining witnesses that you could be calling your own witnesses, but based on what you expect the David's lawyers to call, you think you'd call, you said Venable was your main guy, he's already testified. Is there anyone that you think you might be calling other than the Davids if they don't get recalled?
And that was exactly what I was gonna say. If they didn't get recalled, I kept my questions very condensed today for a reason. And so if they don't get recalled, I could have some additional questions for them, but that would be it.
Okay, great. And Ms. Sturm, what's the thought from the David side?
The thought on witnesses.
Right, because tomorrow morning, I'll say, call your first witness. What do you see? You've now been able to get evidence in through your examinations and whatnot. What do you foresee your presentation being in terms of how long, how many witnesses, et cetera?
We believe we can conclude tomorrow.
Okay. Conclude meaning you would rest.
We would rest.
Okay.
We do have a motion for directed verdict though.
Okay. Let me see my schedule for tomorrow. I have a scheduling teleconference at 8:30. Mr. Williams, can you be here by 8:45 or does that conflict with anything? Okay, let's be here at 8:45, and we'll take up the motion for directed verdict then. If we finish that quickly enough, we'll get going with evidence at 9, but let's plan on doing directed verdict at 8:45. Okay, anything else on the David side? Okay, all right, thank you, everyone. Like I said, if I'm able, I'll try to push a jury charge out to you all tonight. I'll find some time to work on it. Thank you.
Thank you.
Yeah.